if in the meantime the present petitioner relief from the that side of
अरे
it might
meantime
be
भीतर कौन हिच कौन दे meantime भीतर relief कर दोगे. In the meantime, someone relief कर दो बोली कौन? What is the threat? You must show the court. Otherwise, why will it be treated as an exceptionally urgent matter?
that, there is no communication so far. As per information from my client, she had got information that in the meantime today he is relieved from that office.
Also, I will just direct that it will be placed tomorrow before the assigned bench. All right. Let's just matter before the assigned bench tomorrow.
Pardon to
Yes.
make a mention, my lords. Item number 16 from today's second list.
No. Out of turn, out of list of mention.
Face regular second of
Yes.
face regular second of
मतलब टायर्ड ऑफ मैटर ये बिल पहले टायर्ड ऑफ मैटर में लड़ मैंने कुछ हस्बैंड रिलीजन पहले है ना
दियो तो
है ना
modification of
Yes, anything else?
सेकंड अपील दिया 23 रिमाइंडर फेस
Good. What? One per lawyer.
Pardon to mention, my lord. Item number
Through. Any other out of list matters? All right. Yes.
My lords, item number 16 from today's second list, my lords.
Second list no, weekly.
Yes, my lord.
Yes.
RSA 248 of 2024. My lords, here the clients have engaged Mr. Shibashish Mishra. He's on his way today to Odisha. My lords. Kindly it listed for tomorrow.
So it may not reach today. If it reaches, you ask somebody or you be there to just pass it over. You will pass it over. So the marker of the pass over. Yes.
item 5 permitted to withdraw.
Item 5. Of which list, sir?
First list.
Sir?
First list.
Supplementary, weekly daily, all right. Permitted to withdraw.
Okay.
सेकंड अपील दिया 23 फेस
Sir, काली मेंशन करो. आज गोटे मेंशन करछे गोटा ग्राम. जनकु दिनकु गोटे.
Item number 1, election petition.
We are entering appearance today, well, in this case. Me and my friend.
Who's your friend? There are many friends beside.
No, this just behind me. We filed the Wakalatama and we filed a time petition.
Where's that petition?
6 minutes.
Shri Bigyan Kumar Sharma, advocate and associates, have entered appearance for the respondent. आइए
Gopal Agarwal के लिखते हुए सर
नॉल कौन हो असुविधा हो
सर आपण जानो
मैं मुंह किसी जानू एठी बसला पर मैं किसी जानू
your lordship should not forget us.
Far from forgetting you, when Mr. Agarwal is there, that is not necessary, but still there. Shri Bigyan Kumar Sharma, Gopal Agarwal, and associates have entered appearance for the respondent. आइए. And this IA has been filed in the court. The same be registered. In this IA, prayer has been made to grant 6 weeks time for filing of the written statement to the respondent. It is stated that the petition that the upon election present petitioner and his counsel by present that the respondent needs some time to collect documents and to prepare the written statement. Yes, what do you say, Mr. Saman?
Yes, I am. Reasonable time maybe, right?
Reasonable time है 2 weeks तो 2 weeks 2 weeks दिया जाए तब 2 weeks जाओ order रहेगा 2 weeks तापर देखें considering the submissions and the grounds raised 2 weeks time is allowed to the respondent to file a written statement. I don't think the court knows more election law than you.
court is master of all.
Yeah, that is a different matter. So you know why time is being.
But actually, in this case, I need some more time. That's it.
2 weeks time दिया ना आप देखिए. In the other case also, when your senior was appearing, I have granted only 2 weeks time. He had asked for 2 months time, but I granted only 2 weeks. अपन देखिए.
8th October.
Let's just matter on
8th October.
8th October. 2 weeks पर है ना सर. ठीक.
8th October.
Yes.
Item number 2, face admission.
Please. Madam, the petitioner is the husband of the opposite party, madam. My limited prayer, madam, kindly send to the mediation center.
No.
It's because, madam, there is marriage of master dimas of the church college. There is every chance to compromise.
ये मासे दिवस रोई पर नहीं सीता पर.
No, the present petition is the husband.
I know.
Notice me. As because the petitioner.
One chance for you to withdraw, otherwise the order will follow. How is it order?
Both are government servant, madam. She is working as a assistant teacher, headmaster in the government high school, and the present petitioner is the branch manager of.
So it will be difficult for the lady to travel.
The case is pending at Jagatsinghpur, madam. And court in between or 1 and 2 kilometers only, madam.
She has filed.
Mediation center.
Then she should have filed for transfer. If you say that her case,
No,
her house is nearer to Jagatsinghpur, then she should have filed it at
She has been
Jagatsinghpur.
filed before
No.
the Leonard
No.
court, madam.
This is an application filed by the husband.
Humble, kindly.
No, Mr. Patel. No.
Every chance, but there is
No. It is always open to you. A DV proceeding is pending. At any stage, you can have a conciliation. You don't need to conciliate by filing a transfer application.
May I pray one thing, Your Lordship? If Your Lordship would allow to appear on issue.
No, that will be there. That will be there. Wherever necessary, you can appear. But for deposing as a witness, you may have to appear physically. That is also permissible nowadays through VC. It is not a big deal.
Okay.
This is an application filed by the husband and his parents
Father, mother, and the petitioner is the husband. Petitioner number 1
and
is
his
the husband.
parents seeking transfer of
In
DV
between,
miss
mother
case number
died, madam. Petitioner
DV
number
miss
2
case
died.
number 229 of 2023 pending before the learned SDGM Jagatsinghpur to the court of learned SDGM Cuttack. Prayer for transfer has been made on the ground that the petitioners the petitioner is working as assistant manager in a bank at Cuttack.
My Lord, petitioner number 2 died 10 days before, Your Lordship.
And the opposite party is working as a teacher in a school in the district of Jagatsinghpur. Being the assistant manager, the petitioner number 1 has to attend to different training programs and also undertakes frequent tours. Moreover, he being the only son of his parents is has to take care of his old and aged parents. Stop. After considering the submissions and the grounds raised, this court is not inclined to accept the prayer for transfer, as it would be more inconvenient to the opposite party number 1, who is a lady, to travel from Cuttack to
My Lord,
Jagatsinghpur.
male, my Lord, husband, petitioner number.
Sir?
Petitioner number 1, male.
No, opposite party number 1 करें, है ना? Really, to travel to Cuttack from Jagatsinghpur. है ना? In such way of the matter, the transfer application is dismissed. It shall, however, be open to the opposite petitioners to seek permission of the court to appear through virtual mode. Or it shall be open to the petitioners to appear through virtual mode after seeking necessary permission of the court below. So further, the court below shall not insist upon personal attendance of the parties unless absolutely necessary.
May I pray one thing? Petitioner 2 died 15 days back.
This is number 2.
Petitioner, the mother of the petitioner number 1. Due to heart attack.
Delete करो सर.
But,
आगे लिखो first लिखो. It is submitted by Sri R.L. Patnaik, Learned Counsel for the petitioner, that in the meantime, the petitioner number 2 has expired, and therefore her name be deleted from the case. So, considering the submissions, the name of petitioner number 2 is deleted. I would be looking at old and ailing parents to the old and ailing father will old and aged father.
hello, pleasure.
I know 3.
May I please your lordship? I am in VC, my lord.
Yes.
My lord, the petitioner is the wife of the opposite party, my lord, and 6 transfer of CP from Puri to Noyagod, my lord.
All right. Notice. Stay. Date karo.
12th November.
12th November.
Obliged, my lord.
Item number 4.
Oh, my Lord.
Anganwadi worker, my lord.
Yes.
Since 2015, he was served with a notice under Annex 2 at page 9.
ଏତେ ଦ୍ୱାରା ଅବଗତ ନିମନ୍ତେ କହିଛି ତୁମେ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରକୁ ରାଜ୍ୟସ୍ତରୀୟ ବିଶ୍ୱସ୍ତରୀୟ
ସେ ଦେଲେ against a proposed
କଣ
stoppage of
କହିଥିଲେ ଯେ ତୁମ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରକୁ ରାଜ୍ୟସ୍ତରୀୟ ଓ ଜିଲ୍ଲାସ୍ତରୀୟ ଅଧିକାରୀଙ୍କ ସମେତ ସିଡିପିଓ କାଶୀପୁର ବିସି ପୋଷଣ କାଶୀପୁର ମହିଳା ପରିଦର୍ଶକ ମାଣ୍ଡି ବିସି ପରିଦର୍ଶନ ନିମନ୍ତେ ଯାଇଥିଲେ କିନ୍ତୁ ଦେଖାଗଲା ଯେ ତୁମେ ତୁମ କେନ୍ଦ୍ରରେ ବିନା ଛୁଟିରେ ଅନୁପସ୍ଥିତ ଥିଲ କେବଳ ସହାୟକ 3 ଜଣ ଶିଶୁକୁ ନେଇ କହୁଥିଲେ ସକାଳ ଜଳଖିଆ କିମ୍ବା ଗରମ
CDPO competent ନୁହନ୍ତି ଏ notice
ଟିକେ
ଦବାକୁ।
ଟିକେ yes Mr. Mishra.
CDPO competent ନୁହନ୍ତି, however ସେ ଗୋଟେ notice ଦେଲେ। notice କୁ ମୁଁ reply କଲି Annex 3 ରେ। ତାପରେ କିଛି order pass କଲେନି, ମତେ verbally permit କରୁନାହାନ୍ତି କାମ କରିବା ପାଇଁ କି ଦରମା ଦଉନାହାନ୍ତି। ମୁଁ Annex 4 ରେ collector ଙ୍କୁ move କରିଛି। It is in the nature of an appeal.
It cannot be an appeal. It is just a representation.
Yes.
It will remain in the realm of representation
Yes.
because no order, no adverse order has been passed against him. So the question of appeal doesn't arise. It's just a show cause has been issued.
No, they have verbally stopped me. They are not permitting me to work.
Yes.
So it amounts to
Mr. Das, let the
Sir.
collector consider.
Yes.
Yes, within a given time, your
Yes.
lords may fix.
The petitioner was appointed as Anganwadi worker of. Hey, କହିଲୁ କହିଲା ପରେ ଯଦି request କରିବ ଯେ ଏତେ request କଲା ପରେ ଯଦି bar will not cooperate, how can one hold court, sir? The petitioner was working as Anganwadi worker of Kasipur Colony Sai.
Colony Sai.
Kasipur Colony Sai Anganwadi Center in the district of Rayagada,
Rayagada.
being appointed as such, being engaged as such by order dated 21/8/2015. While working as such, the CDPO Kashipur served a notice on her. Served notice dated 8/4/2024 on her, asking her to explain her conduct. The petitioner submitted a detailed reply to such notice on 10/6/2024. No further action has been taken on such in the matter, but it is stated that the petitioner has not been allowed to perform her duties as Anganwadi worker.
And her remuneration has been stopped.
Further, she is also not being paid her remuneration. Stop. Highlighting such grievance, she has approached the collector Rayagada by submitting a representation on 5/8/2024, which has also been registered in the grievance cell of the collector. Stop. Since the petitioner has already approached the appropriate authority, ventilating her grievance, the writ application is disposed of, directing the collector Rayagada to consider and dispose of the representation of the petitioner as early as possible, preferably within a period of 3 weeks from the date of production of certified copy of this order by the petitioner. Stop. Further, the petitioner being in the collector shall also consider the grievance of the petitioner that she has not been allowed to discharge her duties as Anganwadi worker, and her remuneration has also not been disbursed. Stop.
Parties be hard also.
That is key.
CDPO and
Further, the collector shall do well to grant opportunity of hearing to the petitioner and the appropriate government functionaries before passing the final order.
Item number 6. Challenging the order dated 1/7/2023, my lord. Made Anganwadi appeal number 2/22, wherein the petitioner is not considered as an Anganwadi worker, my lord.
You were appointed as Anganwadi worker,
Helper, my lord.
helper.
Earlier, I challenging the order dated, my lord.
No, you were Anganwadi worker, though.
Anganwadi helper, my lord. I am in present Anganwadi helper, my lord. Not consider my application, my lord.
What is it? Why have you enclosed annexure 1? This relates to somebody else, Jasimoni Murmu.
Man, she was appointed as a Anganwadi worker, my lord.
Then
Now,
now,
I am filed a appeal before the ADM more, my lord.
no. You were appointed as, what is the facts? Please tell me the facts.
I am appointed as a Anganwadi helper in
Where is that? Where is that
2007,
order? Where is that order? Annexure 3.
my lord. Annexure 3, my lord.
Yes.
Page 15, my lord.
That was in 2007.
My
Yes. Then what happened?
My lord. One Pratima Manjari Nayak in the same center was retired on attending superannuation on 10/7/2022, my lord.
So there was a vacancy.
My lord.
Yes.
For that post, I am applied for the.
You applied. Then what happened?
And in the meantime, they appointed opposite party number 5.
The suitability has not been considered. How it was appointed? Yes. There was no advertisement.
Yes, my lord.
There was an
There
advertisement.
is an advert.
I think fact happen clearly. Where is that advertisement?
I will not annex.
So there was an advertisement. You participated in this election.
Yes.
And you were not selected. So what is wrong in it?
My lord, my experience is not been counted.
Your experience has not been counted.
The other thing is.
Is there any provision for counting your experience?
Yes, ma'am.
Where is it? Where is it?
Page 15, my lord. Page 10, para 4.
That's all right. That's all right. If found suitable.
Yes.
So first you have to be in the selection process as compared to the other candidates, you must be held to be suitable. There is no provision for granting you extra marks. So what is wrong in that selection process so that I can call for the relevant record?
Other thing is that, my lord, I am continuing as a helper.
All right, all right.
They have not been selected.
No.
As because
They are
I
not
am
bound to
not
select you. The clause
not
4.
in that Anganwadi area.
No, clause 4 that you have just now referred to does not make it mandatory for the authorities to select a Anganwadi helper as Anganwadi worker in all cases. It is not mandatory. So you must tell me if the selection process of that selection process in which the other person was selected, if that is wrong, then yes, this court can consider. Unless you say so. Where have you said that the selection process is wrong? If wrong, how is it wrong? Just take instructions, Mr. Das.
Sir, this is item 5 or 6?
Item 6. Item 5 was withdrawn. You take instruction.
Sir.
The petitioner is aggrieved by selection of one Josimoni Murmu. One
Just you.
Josimoni Murmu.
Yes.
Taka appointment but that was in 2022. So now you have come to the court 2 years later.
Earlier,
Howell. This is stale claim. This is stale claim, sir. There's a 2 years delay. 2022. And after she has been engaged and she is working as Anganwadi helper, worker. Now 2 years later, suddenly you wake up and Howell.
earlier they filed the read petition, my lord. I have had.
କିଛି ଆପଣ ଫ୍ୟାକ୍ଟ ମୁଁ ପଚାରୁଛୁ କହୁନାହାନ୍ତି ଆପଣ ଆପଣ ପ୍ରିପେୟାର କରୁନାହାନ୍ତି ଏଟା କଣ ବାରମ୍ବାର ପଚାରୁଛୁ ଆପଣ ଫ୍ୟାକ୍ଟଟା କହୁନାହାନ୍ତି ଆଜ୍ଞା ଆଗରୁ ଯଦି ଫାଇଲ କରିଥିଲେ କାହିଁ କୋଉଠି ଫାଇଲ କରିଛନ୍ତି କୋଉଠି ଲେଖିଛନ୍ତି ସେଟା ସାର୍ କୋଉଠି ଲେଖିଛନ୍ତି କୁହନ୍ତୁ where have you written it earlier you had approached this court
Yes,
what happened
withdraw, just to withdraw.
ପଢିବା ଆଜ୍ଞା there is no case sir କିଛି ନାହିଁ 2022 ର ମ୍ୟାଟର ଆଉ ତାକୁ କରିବ ବି you should have challenged it immediately if you had any grievance or if you have had any case then you could have challenged now at this belated stage it's not possible yes I am dismissing it ହବନି ହବନି 2022 ର ଆଉ କଣ ହବ
23
Hmm?
23 ର order
no 23 ର କୋଉଠି ଅର୍ଡର 23 ର କୋଉଠି ଅର୍ଡର
ADM
I had this.
who was appointed that Rupasri Mahanto
No, just see money.
sir ଆପଣ ପଢି ନାହାନ୍ତି ଫ୍ୟାକ୍ଟ କଣ ହେଲା କଣ ଆପଣ ଆପିଲ ଫାଇଲ କରିଥିଲେ ସେଟା କି କହିବ ସେ ଆପିଲଟା ବି ବର୍ଷେ ତଳେ ଡିସ୍ପୋଜ ଅଫ୍ ହେଲାଣି
Say appeal order against Astile High Court. So
Hmm.
High Court passed the order, my lord, 8/8/2023.
what was the order please permitted to withdraw so there's no order was passed you just permitted to withdraw so that will not extend the period of limitation not limitation but the delay 4/7/2023
4/7/2023 ADM held the selection of Yasimani as justified.
yes so you must show what is wrong in this order of the ADM
My lord, I have dismissed, I have not selected because of I have the North Center area, Anganwadi Center area, because, but I am working as a helper in that Anganwadi Center. First thing. Second, my lord, I have more qualified than Josimani Murmu.
we'll take instruction so that's
No, in fact, the guidelines say Anganwadi helper and organizer, if having the requisite qualification and are found to be suitable.
yes
So suitability will also relate to being resident of within the area.
yeah but if she is working as the helper of the same center
Yes.
so the question of residence will not arise there is one part Learned AGA Sri Ardas accepts notice on behalf of opposite party numbers 1 to 3 issue notice on opposite party number 4 by registered post returnable within 4 weeks requisites be filed
29th October.
20th. Requisites be filed within 3 working days. Place this matter on 29th October. The Purvu Lakandu. The State Council shall produce the file relating to the selection committee file for perusal of this court. Hela. Tapor place this matter on 29th October. Yes.
Item number 7.
Challenging the termination order of the Anganwadi helper. This is annexure 5/27.
Yes. जाल विद्यालय प्रमाण पत्र पर चाकरी बहिष्कार संपर्क में द्वारा आपको अवगत कराई दिया जाउछि जे आपनको नियुक्ति समय आपनकर बयसगत प्रमाण पत्र पर बलदेव जी उच्च विद्यालय मंजूरी को दाखल करते यही एसएलसी को तदंत कला परे ताहा जाल और मिथ्या प्रमाणित हेबारु जिला गणमाध्यम
भद्रक आदेशनामा अनुसार आपको सहायिका पद बहिष्कार करा what is the order of sub collector that's not communicated only the communication by the CDPM.
But Mr. Naik, if fact remains that the document is fraudulent or fake,
No, that's behind the back of my inquiry has been done.
yeah, this court will grant you opportunity, but that will be rendered a empty formality if the document is proved to be
Whether I have
fake.
submitted or not, that is to be proved or not.
What is to be proved? अपना विद्यालय ये तो
Whether I have submitted and that's my document or not, that is to be seen. And
No, no,
I should have been provided the opportunity to defend my case at least.
yeah, that is true. That is true.
Last 25 years I am.
That is
sitting
true.
Yes.
That is why I will ask him. I said that I will ask Mr. Das to find out to produce the file and everything.
there. Yes.
Yeah. So, but that will not absolve you ultimately if the document is found to be fake.
Yes.
Then DGA shall obtain necessary instructions and in particular furnish the to produce the order of the sub-collector basing on which the impugned order has been passed or was passed. Impugned order was issued. Will go then. Stop. Let's this matter on what is ordered.
8th October. Sir. 8th October.
8th October. Yes.
I don't know.
The interim order.
No interim order. Yes.
Conducting counsel has some personal inconvenience. Lordship may kindly adjourn it to tomorrow or day after.
Okay, we'll go. Let's this matter tomorrow as well.
I'm grateful.
Item number 9, pattern matter.
9 level, Madam Chairman, possible.
That's all. TRP টা কোন পার্টনার রইল গো TRP আচ্ছা ওকে TRP
Item number 10.
Here you also may remember that by virtue of the stay order also, that the Honorable Judge Hon'Ble could has disposed of the 2 applications, 2 proceedings. One is
Oh,
also-
did you find out that judgment?
2 judgments I had tried out, but I couldn't get the your lordship's judgment. I had tried to level.
I had asked you to contact him. ଆପଣ ତାଙ୍କୁ କଣ୍ଟାକ୍ଟ କରିଥିଲେ ସେ କହି ଦେଇଥାନ୍ତେ ମୁଁ ଆପଣଙ୍କୁ ତାଙ୍କୁ ଦେଇ ଦେଇଥାନ୍ତି
Tomorrow ରଖୁନାହାନ୍ତି।
Let's just matter tomorrow as well.
Under 2
ମତେ ଟିକେ
judgments,
ଶୁଣ ପ୍ରଣବଙ୍କୁ କହିବ ଗୋଟେ ଆମର ଯୋଉ ଫରେଷ୍ଟ ମ୍ୟାଟର୍ସ ର ଗୋଟେ ଜଜମେଣ୍ଟ ହେଇଥିଲା why didn't you I asked you to also contact Mr. Digambar Mishra
ଦିଗମ୍ବର ମିଶ୍ରଙ୍କୁ କଥାବାର୍ତ୍ତା କରିଥିଲି।
ତାଙ୍କରି ମ୍ୟାଟର
ଦେବେ ବୋଲି କହିଥିଲି ତ
ସେଟା that's also a reported judgment anyway
ରିପୋର୍ଟ ଖୋଜିଛି ରିପୋର୍ଟେଡ
ରିପୋର୍ଟ ମିଳୁନଥିବ କୋଉଠି ଦେଖେ
କିନ୍ତୁ 2ଟା ଜଜମେଣ୍ଟ ମୁଁ ପାଇଛି ଜଷ୍ଟିସ ବିକେ ନାୟକଙ୍କର ୟୋର ଲକ୍ଷ୍ମୀ କାଲି
that it is a nullity
yes
that it is a nullity so status quo it will be restoration of status quo ante
even application is not required
Not
on the
required.
basis of relying upon the judgment of the Supreme Court on this sort of judgment
well tomorrow ରହିଲେ ଆପଣ ଆଜି ନେଇଯିବେ ଆଉ
ଆଜ୍ଞା।
yes
Item number 11.
11 is yours same
10-11
yes
Item number 12.
yeah please judge
କାଉଣ୍ଟର ଫାଇଲ କରିଛନ୍ତି ଯେ ସେଦିନ କହିଲି
This can be considered by your lordship, that your lordship called for the records of the Tahsildar regarding the resident certificate on which name I have applied for. This can.
And in this regard, the government has filed counter affidavit along with the documents. That has not been supplied to me.
That can be only considered by your lordship.
Counter ଟା copy
Counter is a document or affidavit.
document ଗୁଡାକ କିଛି ନାହିଁ।
extra copy
ଗତ ଥର କହିଲି ତ
affidavit of the ADM there was a direction Leonard AGA furnishes copy of the affidavit filed by the ADM on learned counsel appearing for opposite party number
5.
opposite party number 5 in court. Court no nahi jo. Let's this matter on 8th October.
Earlier to that.
कौन आते जागा नहीं कौन करा जाए
Next week.
नेक्स्ट वीक हबो नहीं नेक्स्ट वीक अन्य पाठर मैटर रही तो 4टा कि 5टा कौन ता भीतर केमति तको
Sorry ଯାଇଥାନ୍ତା ସବୁ ଖାଲି
सॉरी कौन करे यस आइटम 13 yes
The last occasion, the brother appearing sub item 2991769. There are 3 points here, it has been raised. That
you are appearing for Sanjukta Naik, you are appearing for Puspanjali Pradhan.
my
Yes. And state is the opposite party in both the cases. All right.
here is the order under annexure. IP general challenge at page 24.
Yes.
So Lordship may kindly have glance the relevant portion, page 26. Here is the case, while ADM hearing the matter, remanded to the sub-collector for fresh hearing on the basis of document available on record. So challenging this order, the writ petition has been filed. But my submission no way agreed, because there is no finality.
No, you are the writ petitioner.
No, writ petition, the OP5 here.
You are the opposite party number 5.
I am the opposite party number 5.
Second case.
Second case, 1769.
What about the first case?
The first case, Lordship started, observe that first, that matter should be heard first.
नहीं इसको ठीक है मनोपके जैसे ना मनोपड़ियो कौन मैटर टा कौन
First writ petition has been filed where the sub-collector has declared the selection of the OP5 as bad and illegal because on the date of submission of application he was not procuring the documents.
In the first case.
First case.
Who was the opposite party number 5 in that case?
In petition in the second case. Sanjukta. Sir.
Sir, first case has been filed by one
Puspanjali.
Puspanjali Pradhan. What was the what is under challenge in that case?
Not challenge, because Lordship here the sub-collector passed the order allowing the petitioner as the most selected candidate to be engaged as an Anganwadi worker. That order.
So you want implementation of that order?
Implementation could not be implemented.
So you want implementation of that order?
Because there is an observation that subject.
Yes, Mr. Bali, you place your matter. You place your matter. So I get your point. That is why I must have said that the other matter depends on this matter.
Yes.
Yes. Now, what is this matter you are challenging?
Yes, here in this I am challenging the ADM order.
Annexer?
5.
Annexer.
5, yes.
Here in this case, I am the highest mark secure holder, 69 point some odd. And ADM only remanded that you see the memo number, comment memo number so and so, accordingly decide to the sub-collector. Though he found that I am the highest mark secured, but I could not produce my residence certificate in time. But I have produced it before scrutiny of the document. And they have considered and thereafter selected me. And I am working since 2016. And ADM remanded the matter to the sub-collector, saying that in regards to in final page 27.
Yes.
As such direction is issued to the sub-collector Birmarpur from chairman selection committee to examine the case in the light of the GO for selection of Anganwadi worker and to arrive at the conclusion as per his wisdom, duly following the principles of natural justice. That GO number so and so referred, that GO is, I have annexed also, that is regards to page 48, that is regard to residence certificate issued by the Tahsildar has to be accepted. And the petitioner's name was also father-in-law, and the husband's name found place in the survey list. I have annexed that survey list as annexure 8. And she has, after the advertisement was issued, she has applied for residence certificate, which was received by him on 27/7/2016. But last date of application was 22/6/2016. So, but they have, when they have selection committee finally sat for selection, at that point of time, 1/9/2016.
No, what happened then? This is the order of the ADM. This was passed on 23/11/2017.
Okay.
Thereafter, what happened?
Thereafter,
The sub-collector must have passed an order.
yes.
Where is that order?
That order is there,
That in the second my repeat, sir.
59.
No, so you have filed your writ application impugning this order of the
Yes.
ADM.
Yes.
But it is an innocuous order. It is nothing against you.
ସେ ଯୋଉ କହିଲେ ଝିଅଟାକୁ ଲାଇଟ ରେ କନସିଡର କରିବା ପାଇଁ, so even if he found I am selected, I have supplied, I have given the residence certificate and has secured highest marks. ସେଇଟା ଯୋଉ remand କଲେ, I challenge that remand order. And thereafter I am working.
So after remand, as another order has been passed, you should have challenged that order.
Yes.
For whatever worth.
ତାପରେ ଏଇ ଯୋଉ
No,
remand,
Mr. Bahali, please, it is a technical issue.
ଆଜ୍ଞା,
जो order आपने challenge को चुनती, it has already been acted upon. Another order has been passed. So even if there was supposing I set it aside,
Yes.
that order remains. So you have to challenge that order.
but now they have come up.
They have come up for implementation of that order. Obviously, they will come for implementation because that is in their favor.
ଆଜ୍ଞା,
So you may take time and do whatever you want to.
ନାଇଁ ଆଜ୍ଞା, ତାପରେ ମୁଁ
Court will not advise you.
ଫାଇଲ କଲା ପରେ ସେ ସବ କଲେକ୍ଟର ଅର୍ଡରଟା ହେଲା।
ହଁ ତାପରେ ଯାହା କରିବା କଥା ଆପଣ କରିବା କଥା
ସେଟା 19 ରେ ହେଲାଣି 5
ଯା-
years in between.
ହେଲା
ନାଇଁ ନାଇଁ I'm
pendency any time anything
the
can do.
innocuous order is cannot
So
be
now even if I grant you relief you will not get anything. So take time and do whatever you want. Time ନେଇକି ଯାହା କରିବା କଥା କରିବେ। Why should the court advise you?
amendment କରିବେ ଆଉ।
ମୁଁ ସେ କଥା କହିଲି ଯାହା କରିବା କଥା ଆପଣ କରିବେ ନା ଫିସ୍ ଆପଣ ନେବେ ଆମେ ଆଡଭାଇସ୍ ଦେବୁ ଆପଣଙ୍କୁ କାହିଁକି anyway heard further arguments in part please this matter ଗୋଟେ short date 2 week ଭିତରେ କର ନାଇଁ ବେଶୀ ତା ପୂର୍ବରୁ କରୁନ ଛୁଟି 8th October whatever you want to do in the meantime
ଆଜ୍ଞା,
and whatever you want to file after serving copies so that this copy service by our adjournment only yes
ମହାନ୍ତି ବାବୁ ଅଛନ୍ତି, କପି ଦବାର କିଛି ଅଛି।
ନାଇଁ ନାଇଁ counter ସେଟା କିଛି ନାହିଁ that is the technical point.
I don't know, 14.
item 14 yes
May please, Lordship. Lordship, in deference to your Lordship order, Lordship, I have filed an affidavit enclosing the residence
undertake to
certificate.
file further affidavit in course why further affidavit what
Lordship, on the last occasion, Lordship, I have taken time to certify that I am a resident of that locality. The Sarpanch of that village, Lordship, he has given a residence certificate which I have annexed, Lordship.
why are you waiting to till the last moment to serve copy when you know that the matter is going to be taken up last moment you spring a surprise on the other side
Lordship, on the last occasion, I had informed my learned senior, I could not serve copy, Lordship, thinking should be
yes
Lordship.
what is the fact what are the facts
Lordship, in this writ petition, the petitioner is challenging the appointment of opposite party number, the private opposite party number 7, who has been appointed as the Anganwadi worker in Gambhariguda 1, Lordship. Lordship, in pursuant to the advertisement, that is, Lordship, under Annexure
1
page 12, Lordship, the petitioner applied for the post of Anganwadi worker, Lordship. Therefore, Lordship, the fact of the case, Lordship, is the petitioner has secured more marks than the opposite party number 7. In spite of that fact, the opposite party number 7 was appointed in place as Anganwadi worker in place of the petitioner, Lordship. Lordship, we have already annexed the residence certificate, the scheduled tribe certificate, everything was annexed. My candidature, Lordship, has been rejected on the ground that I do not belong to that area where the Anganwadi center is located. But Lordship, it is pertinent to mention here that none of the documents of the petitioner and also of the opposite party number 7 states anything whether they are the resident of Gambhariguda 1. only it states that they are the resident of Gambhariguda. Lordship, the Aadhaar card, the voter ID, everything, PAN card, everything, it states only Gambhariguda. None of the documents of both the petitioner as well as the opposite party number 7 states anything whether they are a resident of Gambhariguda 1 or not. Lordship.
So what is the selection committee resolution?
Lordship.
If at all there is any, I think there is one copy of the merit list. Dhanmati Bhoi Gambhariguda. ଆପଣ ନୁହନ୍ତି ବୋଲି କୋଉଠି ଲେଖା ହେଲା?
My lordship, lordship may come to page number. Page 29, lordship.
The appellate order.
Appellate order of the which was challenged before the ADM, lordship. Page 29 of the merit. Last para, lordship. My lord. The respondent Srimati Dhanamati Bhoi alias Maji has also stated she married.
Who is Dhanamati Bhoi? Your client?
Opposite partner.
Yes, yes. Dhanamati Bhoi has also stated she married to Ponok.
She is married to Jasketan Maji of Gambhariguda village on 26, 2014. As her father-in-law was working in Kalahani district, for which their family were resided in Kalahani district for some time. Since 2018, they have returned back to their native village Gambhariguda and staying there since 2018. Also verified the ROR bearing Khata number 53 of Gambhariguda Moja under Tondahandi Tahsil, recording the name of Jogeshwar Bhoi, father-in-law of the respondent number 1. Also perused the residence certificate issued by the Tahsilar Chondahandi, where it has mentioned that the respondent number 1, Srimati Dhanamati Bhoi,
Dhanamati Maji.
Hon'Ble Maji, wife of Jasketan Maji, is a native, a permanent resident of Gambhariguda village of Chondahandi, showing the house of appellant and respondent and confirmed that the appellant house is coming under Anganwadi center number 2 of Gambhariguda village, and the house of the respondent comes under Gambhariguda 1 of Gambhariguda 1 of the village.
This was a application for which center? 1 or 2? 1. So he says that the respondent house of the respondent number 1 comes under the Anganwadi center 1 of Gambhariguda village, and he also perused the map prepared by the CDPO showing the house of the appellant.
The contention of the appellant, that is the present petitioner, that the respondent is not a resident of village Gambhariguda is not proved. In view of the elaborate discussion made supra and as per the report of the CDPO of Chondahandi, and after verifying the relevant documents, I am convinced that respondent number 1, Dhanamati Bhoi alias Maji, is a resident of Gambhariguda village after being married to Jasketan Maji with effect from 26, 2014. It is a settled principle of law that after marriage, woman becomes a native of the village of her husband. Also convinced that her house is coming under service area of Gambhariguda, AWC 1. Hence, the claim of the appellant has got no merits and liable to be rejected. So the appeal is duly rejected.
What is wrong in this order? Very clear-cut finding. That you belong to the service area of respondent, the Anganwadi center 2. She belongs to Anganwadi center 1. This is a finding of fact. What is wrong in it?
My lord, this order of the ADM has relied completely upon the CDPO's parawise report of the CDPO. No independent inquiry has been done. Lordship, my respectful submission is, and I am constrained to submit this before your lordship, that the CDPO was hand in gloves with the RI, and on that basis, even though the petitioner belongs to Gambhariguda 1, he has been stated to be residing at Gambhariguda 2.
Okay. Even assuming, supposing, accepting what you are saying is correct, are you claiming to be more meritorious than her?
Yes, sir. I have scored more marks than the opposite party number 7.
Yes, what is the stand of the state?
State has filed no counter.
State, the counter is necessary in the
allegation has been made.
Yes, certain allegations have been made against the CDPO because he has relied upon the map prepared by the CDPO. If the map has been wrongly prepared, then he has a case.
And lordship,
and what is your stand, Mr. Mahathi?
I am only stand on the findings of the appellate authority.
All right. After hearing heard further arguments in part, after hearing learned counsel for the parties, this court feels that a counter by the state is necessary to, in view of the allegations made by the petitioner regarding the map prepared by the CDPO. Stop. List this matter. On 22nd October.
Item number 15,
Obliged.
15 are permitted to withdraw.
item number 16.
Item 16.
Yes, my lord. Petitioner had applied for the post of Secretary Act 2011, being brought to vocational post. That vocational post was 2008, my lord, past year passed. Only point made from my lord for consideration, last time my petitioner had appeared on that time now. 2006, that was to arts and commerce giving recognition, giving the equivalency by the.
There's a counter as a counter by the CHSC.
Counter is fine.
The last time it was not on record. That is why I had. You are opposite party number 2, CHSC. Yes, yes, it is there on record.
There.
Yes.
Only 2000.
What is your grievance?
Grievance is that I passed +2 vocational 2008, my lord. 2011, not even advertisement issued by the collector. I applied, selected. But while considering appointment, even though similar persons having the qualification given appointment, mine is rejected on the ground that 2010 CHS has given recognition to that subject. My submission is that 2006 they have given recognition to arts and commerce. Science are given 2010 admittedly. But in the meantime, I passed in 2008, my lord. Similar person given appointment, I given the name under annexure 11, annexure in the agenda. But mine is rejected on the ground because that recognition is given to 2010. So your decision can't consider. You only want to decide. I passed on the 8th.
So how will it have a retrospective application?
2006 they are given science, arts and commerce.
Apart from that violation, discrimination part we will.
Only and others and similar persons have given appointment by the collector that they admit in I have given their.
There are two aspects. First aspect is that you think that recognition granted by the CHSC in 2010 can have a retrospective application which prima facie I don't accept. Your case only stands only on the ground of discrimination.
Only that.
Yes, Mr. Author.
Nothing else.
So far as the council is concerned, I have filed my counter. Kindly see my counter.
In 2010, you granted
not only 10. In that document, we have, unless you challenge that, you cannot get any relief. If Lordship see that document annexure B/2.
Yes.
Kindly see, my lord. The bottom part, page 6. This order will come into effect immediately from the date of issue of this order. So, you specifically stated to be prospective. Arts and commerce were given 2006. Science, the power of declaring equivalent only lies with the CHSC. And CHSC, why it was done in 2010? The reason being, concerned science subjects were introduced in vocational course in 2010.
Obviously.
So, before that, those subjects were not taught in vocational.
So, there was no occasion to.
So, where is the question of equivalence prior to 2010?
Okay. Now, so this takes this shifts the burden to the state. If such is the case, and as I have made it very clear that there will be no retrospective operation of this document, and they have also mentioned it that it will come into effect from a particular date.
Yes.
So now you have to satisfy how you could appoint others, what he claims. We do not know.
That is, I even on the agenda.
So far as we are concerned, our stand is
your stand is clear,
and it is not equivalent prior to 2010.
That's all.
Because the subjects which were taught in 2000 science were introduced in vocational course only in 2010.
Anyway, that your order speaks so.
Right.
That it will be from a particular date.
Correct.
So now the state has to satisfy how they could appoint others if such is the case. That is what he claims. I don't know.
You have given the documents.
Can I say document?
Kindly say page 8 of the rejoinder.
Page 8.
My lord. 22/12/11.
Sir, page 8 of the rejoinder.
My lord.
There's no page 8 of the rejoinder. It finishes at page 4.
The rejoinder of the earlier counter to the state, my lord. This rejoinder for the council. Earlier rejoinder filed counter filed by the collector.
So
annexure 10 to my.
Okay.
Page 6 of the rejoinder.
You are hereby called upon to appear with the. Well.
At page 8. One Madangi, Srimati Madangi, Sanjeeva Rao. She are in the appointment equivalent. That are not never disputed by the opposite party.
No, that I have to explain.
That only.
Nothing else.
But how do we know that she was also?
Yes, that under RTI, I obtained, under RTI Act.
No, RTI you have obtained. तारो parity अच्छी बोली आपन संगे. How can you say that?
Under RTI, I applied.
Parity.
They are never disputed.
Mr. Mahathi, what is the? You are claiming parity with this person, so you have to show the.
Qualification.
So you have to show that she acquired the same qualification as you.
Me.
Yes, at par with you. That you have to show.
That are specifically mentioned it, they are never disputed.
All right. Yes.
They are never disputed.
Paragraph 7 of the counter filed by the
Never disputed.
opposite part number 4, your lordship, the district
Yes.
project coordinator.
But this is a rejoinder filed after your counter. Anyway,
There-
paragraph 5.
7.
7. Yes, please.
In the vocational examination, he did not appear in any of the science subjects towards the middle. It is pertinent to mention here that the Council of Higher Secondary Education, by its notification dated 14/2/2011, had notified that candidates, those who have passed vocational education from CHSE having physics, chemistry, mathematics, will be considered equivalent to +2 science. Since the present petitioner doesn't possess either physics, chemistry, mathematics as one of the subjects in vocational course, his qualification cannot be treated as equivalent to +2 science.
Yes.
Then the notification of the CHSE
I given my document.
A/4.
That I have given the documents of my qualification. I have passed +2 physics document. That I have given with the in my rejoinder.
In a rejoinder?
Yes, page 23. I given basic foundation.
Page 23 of your rejoinder.
Rejoinder.
No, basic foundation course no. Separate subject हवा दरकार. Foundation course तो समझते सब जिनिस देखला.
No, basic foundation course that I have given the mark sheet also, my lord. Kindly see the page 22, 21.
That is.
By that time. There you go. এটা council law. Council law. Board of secondary education.
Page कितने?
Page 21.
+2 certificate ना vocational certificate
এটা +2 पे.
+2 ହେଲେ କେମିତି ଦବ vocational ଅଲଗା +2 ଅଲଗା ଆପଣ vocational certificate ଦେବେ ନା ତାମାନେ ଆପଣ +2 ପାସ୍ କରି ଆଉ ଥରେ vocational ପାସ୍ କରିଦେବେ
No.
ସେକେଣ୍ଡ
General foundation course pura.
ନା ହବନି ସେଟା
Count.
सर सेटा देखुन सेटा +2 सर्टिफिकेट तामाने +2 थरे
These are
पास
not
करे आउ थरे vocational पास
की
करे
करिबनी.
that become
That I have held in one judgment of mine.
already judgment
ନା ସେଟା ତ
I have also pronounced a judgment in that regard.
ଫର୍ଜରୀ ପଡିବ.
से
ସେଇଟା ନୁହଁ.
एटा की देखो
ये clear होनी?
ନା ସେଇଟା ହଉଛି what I submit, sorry.
It is a diploma in elementary education.
I submit their qualification. That person appointed, they are also the same qualification of that foundation course. That's sorry, madam. This person, those two person, they have still passed. That is.
So you have to answer this only.
This only.
Yes, Mr. Das.
Sir, in the rejoinder, he has, my friend's client has stated the course of paragraph 5 of the rejoinder.
Yes.
The course of vocational education was changed from the year 2010, not including the subjects of physics, chemistry, mathematics, biology, and for the said reason, the CHSE might have issued a different letter during the year 2011, indicating that vocational examination is not equivalent to +2 council examination.
And we are giving the rejoinder, we are not replied at all.
So you have to reply to the rejoinder
Yes,
actually.
only one.
But you don't, but I mean, I'm not asking you to reply, but by way of an affidavit, but at least the only thing that the court will see is that from Mandangi Sanjeeva Rao,
Amai.
there are two things. First, whether his case is identical to that of the petitioner, and secondly, if he could be granted given, why not the petitioner? That's the only question. Heard in part, let's this matter. No, heard in part. Learned AGA shall specifically take instructions with regard to the averment made in the rejoinder under paragraph 8. Let's this matter on
22nd October.
22nd October.
Okay.
Yes.
copy down
Yes.
I cannot 17. Yes, ma'am.
Yes.
But on the last occasion, with respect to the
latest physical disability certificate dated 25/6/2019. I directed to check it from the department about the authenticity of this particular document. I have already written the letter to the superintendent of the ACP Medical College, madam. But madam, there is also some correspondence to me with me, madam, to provide the documents and other things I have already provided. I am yet to receive it, madam. But kindly peruse the impugned order, madam. That was the order which was been passed by your lordship, complying your lordship direction. My lord, the appointment was in the year 2011.
Yeah, don't.
Appointment was in the year 2011. Disengaged in the year 2013. When in terms of the physical disability certificate, she got the appointment saying that she is a physically handicapped candidate of 80%. And there is a requirement to appear before the appellate medical board. And that was not there. So she was given two chances to appear before the state medical board. And on both the occasions, she failed. Thereafter, she was issued with the so cause, and thereafter, she was disengaged from service in the year 2013. Later on, my lord, on the basis of her request, once again, she was allowed to appear in the state medical.
Anyway, a judicial order has been passed.
I'll get that only.
For whatever it is worth, let it be complied with. That these matters,
my lord.
Argument that you are making.
No, my entire submission, my lord, 2 times the matter has been examined by the board, appellate board. Now a certificate of 2019 has been produced to justify the medical certificate of 2000.
As per the direction of
11 or 13. 11 or 13, my lord. Because these documents and these status of the petitioner with respect to his physical handicap or physical handicapness was not the subject matter at the time of taking a decision, the impugned decision, madam. That is my submission. But with respect to the present status, I will get that. This may be taken next week, I will get that.
You see, this is a court of equity. When it's a court of equity, all these facts can be taken into consideration. As I said, only for equitable consideration, yes, nothing else.
This matter may take next week.
Not with a heightened or misplaced sense of justice. Yes. I don't believe in that. It's a question of whatever is on fact, it has to be considered. So judicial order has been passed, so yes, comply with it. Yes. Lana request for some time to comply with the previous order on the ground that he has written to the authorities of the SCB, MCH, but has not received any reply as yet. Place this matter on
1st October.
Yeah?
1st October.
1st October.
Yes, ma'am. Yes, ma'am.
1st October. Yes, Mr. Pandey. Slow. Yes.
I don't know, 18.
Qatar to won't be slowly work.
May I please? In this case, the petitioner.
Item?
18, my lord. 18.
Yes, please.
In this case, the petitioner challenged the order under Annex 1.
Particularly in respect to the order passed by the Australia Odisha Administrative Tribunal in November Annex 10. Yes.
With respect to that particular PEO, my lord, I have got a telephonic instruction, my lord, with respect to that PEO, because he was a holder of the civil post. He approached before the tribunal, alleging the for quashing of that suspension order, my lord, and later on, my lord, that matter was taken into consideration and the order is there, my lord. But in case of the petitioner,
what is the fact? I forgot.
On the ground of misappropriation and other things, my lord, he has been disengaged.
So he was working as
GRS.
GRS. So then, what happened?
But with my lord, on the
did you file appeal? Did you file appeal before the Director of Special Projects?
Here we discussed that there is no appeal provision after disengagement.
GRS,
right? GRS appeal.
Comprehensive guidelines. You look at the comprehensive guidelines. Against the order, appeal lies to the Director of Special Projects. Whether I will direct you again, relegate you or not is a different matter. But there is an appellate authority.
And the order is of
31/5. Notification as per my lord.
Notification
in 2018 as per my submission of my lord senior.
2018 in some cases also.
This order was passed on 31/5/2018.
18.
Yes, 2005.
Yes. Annexure 1, my lord.
So when were the comprehensive guidelines issued?
That's the one they did.
Comprehensive guidelines am nahi bode. Eta se Anganwadi ro achi.
No, GRS mu ଦେଇଛି.
GRS ବି ଅଛି. Give 6/4/2018. So this will come under
31/5, my lord.
31/5 will come under SCO.
Since 2018, we have.
All right. This is since 2018, but if it is a factual aspect, then this court will not enter into. Only otherwise, if on a point of on a question of law, if it can be decided, well and good. Otherwise, I'll have to relegate you to the appellate authority. What do you say?
As your lordship.
No, what is the point involved here?
We have given the adequate opportunity. So cause was issued and thereafter he submitted, of course, taking into consideration the same, the order was passed.
On what ground have you filed the?
My case before your lordship that there is no iota of evidence regarding misappropriation of
It is
the money by
evidence.
the petitioner and no other persons also. There are 3 persons entangled in this incident and 2 have been already
This
reinstated.
is a factual aspect.
And
This can-
there was no framing of charges,
No, sir.
no personal hearing.
Sir, please listen.
Sorry.
If had it been only on a question of law, impropriety of procedure, or like no opportunity of hearing granted, then this court could have ignored the
Right.
alternative remedy and considered the matter. But now whatever you are saying is entirely on facts. So you better file appeal. I will direct him to consider it and dispose it of within 1 month. So that if you are not aggrieved, if you are further aggrieved, you can come to this court.
Yes, ma'am.
Again, not on facts. Yes. You are Mr. Sethi.
Right.
Heard Sri Digambar Sethi.
Right.
Heard Sri Digambar Sethi, learned counsel for the petitioner, and Sri Rasan Patnaik, learned AGA for the state. The petitioner has approached this court seeking the following relief.
What's up?
The facts of the case are that the petitioner was engaged as Gram Rojgar Sevak, bracket GRS, under K. Singhpur block, Kalyan Singhpur bode, on Kalyan Singhpur block of co-district seta,
Rayagada.
of Rayagada district, by order dated 21/6/2013. While working as such, he was asked to show cause by the BDO, while letter dated 4/4/2018, as to why necessary action
And
shall not be
3
taken against him
2 so for this and 6 4. Sorry.
on the allegations of committing irregularities and misappropriation of PMAY House Fund for the year 2016-17 and 2017-18 in Seriguma GP. So, another show cause was issued by the collector on 6/4/2018 containing the self-same allegations. The petitioner submitted her detailed explanation, but the same was not considered, and by order dated 31/5/2018, he was disengaged as GRS with immediate effect, as per order passed by the collector. Collector Rayagada. Stop. All right. Sri Sethi, learned counsel appearing for the petitioner, submits that in the so-called inquiry conducted to ascertain the conducted to establish the allegations, the no evidence worth the name was found to justify the action taken against the petitioner. In other words, the allegations of misappropriation of funds, comma, according to Sri Sethi was not proved at all. Stop. Sri Patnaik, learned AGA, on the other hand, submits that the question, the issues raised by the petitioner, the grounds raised by the petitioner involve facts, comma, which may not be gone into by this court sitting in writ jurisdiction. Sri Patnaik further submits that even otherwise, a remedy of appeal is provided against the order of disengagement. As per remedy of appeal is provided against the order of disengagement, comma, which the petitioner ought to have availed at the relevant time. This order was passed in 2018. You filed this writ application. No, earlier also you had probably come. You filed it in 2023.
No, 2018.
Writ petition done.
10075.
Well, ठीक. So मासे भीतर file करो. मासे भीतर file. So it is in time. It will be treated as in time. Hello. Okay.
12/6/18 I have.
Yes. No, you have filed 22/6 में लिखा है SR में. अच्छा 12/6 रे अपन file करछन. Which is within 1 month. Yes, within 1 month. Para. No. Tell us a comprehensive guideline. After hearing learned counsel for the parties, this court finds that as per the comprehensive guidelines for selection and engagement of GRS under MG and NREGS issued by the government in PR and DW department on 6/4/2018, the remedy of appeal is provided against the order of disengagement to the Director of Special Projects. Director of Special Projects within 30 days from the date of passing of such order. As already indicated, comma, the petitioner has raised several factual issues which this court would ordinarily be slow to consider while exercising writ jurisdiction. On the other hand, an alternative efficacious remedy of appeal, alternative efficacious remedy is available to the petitioner, comma, which he can always exercise. In such view of the matter, the writ application is disposed of, directing the petitioner to prefer appeal before the Director of Special Projects within 2 weeks from today. Stop. In case such appeal is preferred within the stipulated period, comma, the appellate authority shall consider and dispose of the same in accordance with law after granting opportunity of hearing to all concerned, including the petitioner. Stop. Be it noted that the impugned order was passed on 31/5/2018 and the petitioner filed the present writ application, comma, rightly or wrongly, on 12/6/2018, comma, which is within 30 days from the which is within 30 days from the date of the passing of the impugned order, date of issuance of the impugned order. In such view of the matter, the petitioner is granted further liberty to file an application for condonation of delay along with the appeal, which shall be allowed, taking note of the fact that the petitioner had approached this court within the period of limitation. Yes.
1 month, your lordship. Within 1 week.
Only disposed of in accordance with law within.
September.
After granting opportunity of hearing to all concerned, लिखले seat खाली add कर दूँगी. जेडी 3 months with लिखा है सेतरे grant.
फाइल करके आउ केते
सेतरे अच्छी 3 months भीतर से dispose of करियो. सेत पे in accordance with law कर ली. Yes. आउ किसी दरकार. Yes.
सेटा स्पेसिफिक न रहले से डेरी कर दो.
ने डेरी कर परिबिन ताकर जहाँ अच्छी ना in accordance with law को आगला हो. जदि गोटे when something has been provided, a time limit has been provided, this court cannot enlarge it or reduce it. Yes.
No plus.
Item 19.
Number I didn't. Password कर दे. गोटा password दो. Password.
Item 20. Friend has to file a counter in this.
Yes,
matter,
ma'am.
Madam.
You're filing? No, madam.
From contact, can it be?
Submit that his case is squarely covered by the order dated in Vichitrananda Behera versus. He files a copy of this order. Oh, yes.
A copy of the same has also been submitted.
You were directed only to consider whether it can be, I mean, disposed of in light of that order.
Prima facie, my lord, I am not.
Right.
I have the opinion, my lord, this is not covered.
But all right.
Only with the.
Why are you so apologetic about it? If according to you it is not applicable, not applicable.
Sir.
We will consider. The court will consider whether it is applicable or not.
Yes.
So one chance has been given to you.
My lord, but we have not filed any counter in this case to rebut the factual aspects.
Is it necessary then?
Can 1 week, one more chance will be given.
All right.
It's covered.
Sri Asan Patnaik, Learned AG submits that the judgment passed in Vichitrananda Behera's case would not be applicable in view of the, would not be applicable to the facts of the present case. Would not be applicable to the present case. He further requests for some time to file counter answering the factual issues. Answering the factual aspects. This is 2022 matter. So I will grant you.
First week of October. First week of October.
Place this matter on?
1st October.
8th October. 8th October.
Yes.
Item 21. 21 on behalf of Mr. Ratman can be passed over. He was inside the court.
Password.
Item 22.
The petitioner was appointed as Anganwadi worker. He was to retire as per the pre-revised guideline. He was to retire on 3/3/2024 manner. Inland the government enhanced the age of superannuation for another 2 years, subject to fulfillment of certain conditions. Accordingly, that condition stipulated in clause number 4 of that guideline, the petitioner that must be accompanied with a medical certificate. The petitioner, after obtaining medical certificate, submitted his application in a prescribed format in under Annexure 3 on 4/1/2020.
Annexure 3.
Workers by Srimati Salwala Ponda and Srimati Nirudin Naik, Anganwadi worker of Mundarguda, and Jamuna Bhal, AWC, desperately are enough capable, good health, and good sense of responsibility to care of AWC family. It is therefore I would like to request to allow the extension of service of the above stated AWS provision granted by the government in view of the willingness of AWS and also public interest. My lord, when no action, no communication was made to the present petition with regard to the extension of service, we approach your lordship. Under Annexure 5, that petition was disposed of, your lordship directed the sub-collector Junagadh by in his letter to take a decision in accordance with law as early as possible, preferable within a month from the date of production of certified copy of this order by the petition. Since it is submitted that the petitioner has been allowed to continue as Anganwadi worker, the CDPO, she shall be allowed to continue as such till a decision taken by sub-collector in terms of this order. Now he has been continuing by virtue of this interim order. My lord, No, thereafter, the decision taken by the sub-collector was not communicated, has not been communicated to the petitioner till date. He approached the open number district social welfare officer. The social welfare officer under Annexure 6 gave the copy of the communication made by the sub-collector to the district social welfare officer, where he has stated that he has not approved this extension of time, and para 5, Hon'Ble High Court of Orissa has now directed to take a decision in this matter in accordance with the law within 1 month. For kind information of the Hon'Ble High Court, it is to mention that the decision was taken as per law and in accordance with the guideline. In case of interpretation, the above guideline have been made by the department and have been communicated to district office, by virtue of which the decision needs change. The same may be communicated to the office for reconsideration of the matter.
What is the meaning of this?
And thereafter, my lord, now the highlight counter, my lord. In the counter, he has annexed a letter of the present petitioner under annexure DB5. That is it is there stand that the petitioner submitted the application on 16/1/2024. With this regard, the petitioner in his rejoinder has stated that first he submitted the application to the office. On that date, the CDPO was absent and he handed over that application to the clerk. Thereafter, he had been to the office of the CDPO to know about the status of his application. And CDPO told him that clerk was in leave, so you give another application. So on the spot, he gave that application without mentioning date. Your lordship, and there is a ODI written and date has been mentioned in English. The date has not been mentioned by the present petition. And thereafter, he sat about the matter and communicated to the same to the forwarded the same to the sub-collector for approval. The sub-collector under Annex 3/5, it has not been communicated to us that there is a 40 days delay, and he denied the approval. Thereafter, the CDPO begged apology and again resubmitted the proposal. Now, this is the status of the case, Malas. Admitted there is 1 day delay because as per guideline, he was to submit his application on or before 3/1/2024 and he submitted 4/1. This is the 1 day delay. And this is the latches of the CDPO to forwarded her application. Now the counter here, sir, if he is allowed, a floodgate will be opened. That is their stand. And by virtue of the interim order, the present petitioner has been continuing in the duty. So my respectful summary, your lordship directed the CDPO, the sub-collector, to approve the proposal of the CDPO.
So how floodgates will be opened?
I mean, there is a clear stipulation in that guideline that compulsory retirement age, that is the discharge of the Anganwadi worker, is on attaining the age of 60 years. But it can be extended under some special circumstances. Now, that special circumstances has been indicated in the year 2019, where a stipulation is there that an application exercising the willingness along with the medical certificate is to be submitted clear 2 months before the date of retirement. The language is like this. So, considering for a moment that the first petition was submitted, which we have disputed, on 4/1, that was also after the...
Let us see the letter of CDPO then.
CDPO is expressing her that there is a delay on her part, referring to the 16/1 letter, because it was communicated on 8/2. But shade be 4/1, shade be 16/1. Both are after the 2 years, 2 months. So, once there is no such provision, seeking any condonation of that particular provision at the level of the field functionaries, the guideline which has been framed at the level of the government.
Where is that guideline? Let us see.
My lord, that he has also relied upon, and we have also given it an annexure 3/1. A/1. in our counter matter answer A by 5, 10 to 15 matter. Important one is 12. That is eligibility and process 4.1. Another case is also there today. They are given the eligible copy. The AWWs and so on, so on. So desirous of getting re-engaged after 60 years will give their willingness in the format prescribed in writing to the CDPO clear 2 months before the date of attaining the age of 60, along with fitness certificate issued by a government medical officer in the format prescribed and proof of age given at the time of engagement. Now, at least the petitioner was aware about the date of attaining the age of 60, and the medical certificate is also of 4.1. That is beyond the period of 2 months, my lord. And this particular document, what the petitioner is making a submission that on 4.1 she had submitted an application. That is not a fact. That we have stated. On 16th for the first time she had submitted.
What is the relevant date?
3.1. 4.3.
2 months before ta kebe hochi 60 days
3.1 hochi
3.1 4.1 submit kari
तार 4 जेहेतु तांकर 4/3/2024 होची 60 years, so prior to that date, so 3.4 3.1 on both accounts. This has been a decision has been taken at the level of the subordinates, my lord, who do not have any competency to interfere with the guideline.
That goes without saying, but
and my lord, when the word clear is there, my lord, they interpreted in that.
Clear 2 months.
Clear 2 months.
It doesn't say 60 days.
No.
2 months.
2 months means 2 calendar months.
2 calendar months.
So when was your date of retirement?
3/3/2004.
3/3.
Date of attaining the age of 60 years married, it is 4/3.
So 4.1 will do.
Due on 3/3/2020.
Sorry, 3/3.
3/3.
3/3.
3/3.
3/3
So it will be 2.1, madam.
2.1 haboni. February month is there. Na? 2 months.
2 months. So 3.1 habo. 2.1.
Thao se to achante thao. Heard in part, let's this matter after vacation of date kola.
29th October.
29th October.
Interim order.
Interim order to continue.
Item 23.
Counted up by something.
Sir, madam, I'm challenging the order of disengagement. I was working as an Anganwadi worker. I have been disengaged. Page 75, annexure 11 is the improved order.
Annexure
11, page 75. Wait, please.
I mean, pardon to.
ठीक है Have you filed appeal against this order?
No.
File an appeal.
But here is already my appointment basing on this PH certificate was subject matter of appeal. That appeal has gone in my favor. That was challenged before this honorable court and the writ petition is pending. Now, basing on an FIR, this order has been passed. So, my lord,
You file another appeal.
my lord, because my PH certificate has already been validated and that is subject matter of the
Sir, that will be considered by the appellate
He
authority.
has no jurisdiction because he cannot now review his own order. My lord, my submission is
No, it's not a question of reviewing its own order. This is another order has been passed.
another order has been passed
So that order is again applicable.
only on the ground. Natural justice have also taken.
That's all right. That's all right.
So,
That's
my
all
lord,
right.
my primary submission is that, my lord, my
You,
appointment.
I will protect you till filing of the appeal.
Kindly sit, my lord.
And thereafter, ଟିକେ ଶୁଣନ୍ତୁ ଆଜ୍ଞା ଟିକେ ଶୁଣନ୍ତୁ ଏତେ ତରତର ହୁଅନ୍ତୁନି ମୋଟେ ତରତର ହୁଅନ୍ତୁନି ଓକିଲ ଏଥିରେ ତରତର ହେଲେ କିଛି ହବନି ଆଜ୍ଞା you have to have infinite patience. So I will protect you and you can seek appropriate interim order from the court below, I mean the appellate court. So it doesn't matter whether the writ application is pending here. What do you say, Mr. Patnaik?
Yes, ma'am.
I have two submissions
And
to make on that, madam.
This decision has been taken after complying the direction of this honorable court.
That's CRLMP, non-registration of the FIR.
And there, my lord, this.
Let him.
It has been
Submit, Mr. Rathod. Allow him to. Yes.
Two submissions on that, madam. First of all, there has been a glaring violation of principle of natural justice because the documents and the materials basing on which this proceeding has been initiated, that has admittedly not been furnished to me, because in the counter they are admitting that those reports have not been given to you. This is one. But second, my appointment, I was appointed in 2010. Now, on the petition of one of the contesting parties, applicants for that post, that my matter has come up to before this honorable court. This honorable court has said that, and you file an appeal. That is how that was subject matter of appeal. And the ground of appeal of that contesting applicant was that my PA certificate was not genuine. Now, the appellate authority, by asking for reports from the CDMO, by following the procedure, he has held that no, the certificate is genuine. Now, that was challenged before this honorable court, and the petition has been pending since last 10-12 years, but they are not moving that writ application.
All right. Place this matter tomorrow along with the WCC.
10402 of 2011.
10402.
10402 of
2011. ma'am.
It will come to me, so it is my assignment.
Yes, ma'am.
Sardo.
Intervenor got a file.
It was best of it. It was the okay. Will be affected by intervenor could be win.
Here,
He may be affected by that order.
and he has challenged that order in independent read. This is, I am challenging the termination. So here he is not an affected party, he cannot be an affected party. So he
Well,
can-
tomorrow let it come to Kali. Further. Achha, day after tomorrow. He says the file may have gone to the record room, so there will some time is required to bring it. All right. Okay. 20 दिन कोर्ट नहीं अपन कोई मसी कोर्ट वसी नहीं नहीं कोड़ी तरह के ना मैं रोहूं नहीं आऊँगा कौन कोई
next week 19th
oh चलो I would next week all right please this matter on 24th September along with the WPC numbers also.
Item 24.
The same issue, ma'am. With respect to extension of the age of retirement. Your my lord, we have not filed our counter.
She is continuing.
I think there is an
Continuing by interim order.
there is an
Lawrence State Council requests for some time to file counter. List this matter on
29th October.
29th October interim order to continue. Is there an interim order? Kind. No, interim order to continue.
Item 25.
So this is an application for transfer of wife's application for transfer of matrimonial dispute lots from Borgod to Patnagarh.
What is the status of the case? Has it been stayed?
Stayed. It's not in there.
Whether fresh notice has been served?
Yes, your lordship, kindly say the last order.
Affixture. There was no one in the house. And also the OP lives in Borgod.
But Borgod address is there, lords, in the post itself, lords. And in this address, lords, he is prosecuting a case.
Yes,
Also.
what to do? Notice on affixture. Address is the same. There was no one present, so notice by affixture.
sir. Will
You serve. But attempt not to dispose of unnecessarily that will lead to complications. It is better you give another copy so that within 2 weeks, I'll call it after 2 weeks. So 2017 pending royal and so 2 more weeks, so that at least he will get it served through the police. Let an extra copy of the transfer application be served upon learned State Council, who shall ensure service of the same on the opposite party through the ISC of the jurisdictional police station, indicating that the matter shall be taken up for hearing on
1st October.
1st October. They don't copy these.
Item 26.
I'm for the opposite party. The mediation court has not yet come.
But as per my instruction in
20 তারিখে রয়েছে
20 তারিখে ଅଛି. In the meantime, I have taken instruction that before the CP number 415/2018, for which the petitioner has sought transfer to the Bhubaneswar from Cuttack to Bhubaneswar, the CP 415 has been dismissed on default since 3/5/2020.
Anyway, I will not pass any order because the mediation is pending. Let the whatever, যদি mediation টা solve হয়ে গেল, then that can be also restored and what necessary orders can be passed, isn't it? The report of the mediator indicates that the next date of mediation is fixed to 20th of this month. Hence, list this matter on 1st October.
Item 27.
Yes, item 27.
This is a matrimonial dispute. The wife wants to transfer Jagatsinghpur to Kendrapada. The issue noted about opposite party not received the
I am directed to the verification of issue. It is ascertained the notice on the sole opposite party, so and so, has not been received earlier. Notice पठाइन तंग को बिल्कुल नोटिस से रजिस्टर सिविल कोर्ट को पको पठाइन वही is the office note notice पठाइन था the office to examine the letter dated 5/9/2024 of the registrar civil courts Jagatsinghpur and to do the needful in the matter of issuance of notice. This matter 3 week for 4 week 8th October.
interim order.
Interim order to conference.
Item 28.
In this case, last occasion, the court has directed to result of CMA. Order dated 13/5/2024. But CMA is pending in the court. Below date is 15th October. So this case may be after.
Vacation for a Then counsel for the petitioner submits that CMA number 205 of 2024 is posted to 15th of October before a coordinate bench. List this matter
29th October.
on 29th October.
Item 29.
This was issued for appearance.
Neither any report has been received from the IIC regarding service of notice. Yes, IIC.
In 29, my lord.
Dated 29th though?
Yes, ma'am. There we have gotten information from the IIC Sri Lingaraj PS that with reference to the letter and subject cited above, I am submitting here the complaints that as per the direction of the Honorable Court, sincere and effective steps have been taken to trace out the opposite party. It is ascertained that Satyavan Mangara, 32 years, so and so and so, is not residing in the above address and the notice could not be served upon the opposite party.
So you have to ascertain the correct address?
Dita address रे जाइतिला. Another Bahuti Sai Doleiput Khurda. And
So ସେଥିରେ ଆଉ କିଛି ପାଇଛନ୍ତି କି?
twice no.
ନା ମୋତେ କେବଳ
ଆପଣ ଦିଟା କପି ଦେଇଥିଲେ?
Since
I have received only
kindly
from
say
the-
annexure
One through the IIC of PS Khorda and the other through IIC of Lingaraj PS. So Lingaraj PS ହେଇଯାଇଛି, ଖୋର୍ଦ୍ଧାରୁ ଆସିନି.
ଖୋର୍ଦ୍ଧାରୁ ଆସିନି,
Next
sir.
week ରେ କଣ? Learned State Council has obtained instructions from the IIC of Lingaraj PS indicating that the opposite party is not residing in the address mentioned in the transfer application. He has, however, not received any instructions from the IIC of Khurda PS. Release this matter next week. Learned State Council shall inform the court regarding service of notice by obtaining instructions from the IIC of Khurda PS.
The said opposite party has filed the application. I have sought for transfer. He has given this address.
You know why it is being done. I'm going to see, Khali, this court will be cannot pass any order unless there is sufficiency of service of notice. Otherwise, it will become bad in law. Once that is there, interim order to conclude. Yes.
Okay. Item 30.
Once the notice is served, anything, even if it doesn't appear, that can be done. Item 30, yes.
Yes, Lord. 4th 10, the next date has been fixed in the
Mediation.
no, the court below, Lord.
So,
TRPC has sought for
My Lord,
already reached its finality. MAT case. So,
Lord,
ये कहते गोटे
they
petition
expert-
expert ହେଇଛି ସେ petition ଟା
expert-
ପକେଇଛନ୍ତି ସେଠି ତଳ କୋର୍ଟରେ ଆଚ୍ଛା ଏଇ ଷ୍ଟେଜରେ ଗଲାଣି 4-5ଟା ଗଲାଣି.
No, they're playing hide and seek, Lord. They on 13th 8.
who is playing hide and seek, that I would like to know.
I'm submitting. Lord. On
No,
13th
who is playing Mr. Naik?
they are Lord.
No.
Yes, Lord. I am saying, who is Lord? On 13/8/2024.
So the application for setting aside the expiry order, on the last occasion you said
Yes,
that it is posted to hearing before the court on that day.
Yes, Lord.
That was on 2nd of September. What
Yes, Lord,
happened?
I'm submitting, Lord.
Yes.
On 13/8/2024, Postal Department delivered the notice. 23/8, that opposite party was expert there. But all on the sudden on 6/9/2024, Postal Department is returning back the envelope. That's why on 6/9, the Lord Court below asked for show cause to the Postal Department. And the next date has been fixed to 4/10 below. And the
So I'll
expert order
simply say
already
4/10.
expert below.
Yes, yes.
Expert order has been passed on 6/9. No, sorry, 23/8.
23.
Yes.
So last time the matter was listed before this court on 2nd of September.
Expert. But then and there on
No,
6/9
on 2nd it was posted. 2nd you said that the matter is posted to today. It means on 2nd of September. What order was passed by the court below on 2nd of September?
Second 23/8.
Do we know it? Order pass Mr. P.K. Naik, learned counsel for the petitioner, submits that the application for setting aside the expiry order is posted for hearing before the court below today.
2/9.
Yes. Hence, list this matter on 17/9.
And this will 6/9 below.
Sir, do you know lekha do you know order hiche?
Not a 6/9 below. 23/8 to expert order.
I don't know.
And 6/9.
Today only kahin lekha hala 2 tarike dino amne submission heithibo to lekha hala na. Am anur to lekha hoboni. There may have been some miscommunication, doesn't matter. Anyway, whatever it is 2/9 or 6/9, what is the present status? It is posted to 4th of October. You agree that it is posted to 4th of October?
I have not verified for my client, I don't dispute that.
So, but if you are, why doesn't your client appear there? So this matter can be disposed of.
The matter has been reached its finality, decree of divorce has been passed.
Sir, but it is if it is an expertise.
He says that now, as my learned friend says, notice gone, return to the with a postal remark that he first of all he says he received. Then he says that the postal authority has returned the. In this situation, I have not clarified for my client.
No,
Anyway,
but he is appearing here. Let them appear, my lord.
This court cannot direct them to appear. It is for them to appear or not appear.
He can suggest their client.
This being a civil matter, the court cannot direct them to appear.
Not my lordship, my lord. I am requesting my learned friend to request
All right,
client to appear there.
All right.
And matter will be understood.
Sri Naik submits that the application for setting aside the ex parte order is posted for hearing on 4th of October.
Yes.
October. He further submits that the opposite party is deliberately not appearing.
Yes.
Learned counsel appearing for the opposite party, however, disputes this submission and submits that that he would instruct his client to appear before the court for hearing of the application. In such view of the matter, is this case on? We'll take it up after vacation.
Yes.
After vacation, good date.
29th October.
29th October. Yes.
In May, final order passed, and the court direct to deposit some amount. I have deposited decree of final decree of divorce has been passed since May.
Supposing he does not allow. Then end of the matter.
Exactly, my lord. Exactly.
So if a petition is pending, let it reach its conclusion.
Then this Lord Civil Court has passed a decree, again he can revert back to the.
Yes.
Item 31.
31. Yes.
Well, I am respondent.
ठीक है रोजन पासवर्ड.
Item 32.
May I plead your lordship? Your lordship, on the last occasion, you had directed to give a status of all the disputes pending at Bhubaneswar court.
Permitted to furnish the status of all the cases filed with the opposite party said to be pending before the Supreme. Yes.
Your lordship, regarding the divorce proceeding, the reconciliation has failed, the trial is yet to start, and
What is the status of all the cases?
your lordship, you are just directed to.
To furnish the status of all the cases, how will you furnish?
Your lordship will be submitting the report.
Why have you not? Why are you not ready with the report now? You should have prepared a status report
My
or a
apologies.
list of cases.
My apologies, your lordship. We'll be submitting it.
Let this matter tomorrow. The previous order be complied with.
Grateful, your lordship.
Item 33.
Your lordship, there was an interim and
Interim order to continue. Yes.
See, my lord. Lord, the next date of mediation is on 20th, my lord. So I pray, my lord, on.
The report of the mediator indicates that the next date of the mediation proceeding is fixed to 20th of this month. List this matter on
1st October.
1st October.
Interim order to continue.
Interim order to continue.
Item 34.
That person. Last order, your lordship, kindly see. Lordship directed the state council to take stock.
Regarding the allegation of assault on the petition accused, this incident. Further proceeding has been stayed.
Yes, sir.
The affair that PS case 57 of 2023, Muniguda, that has been ended in final. Case is false. Lady teacher in a crowded area, allegation of arms act. Yes, assaulted. It's
See the
false,
wife,
my
my
lord.
lord. See, he was serving there. He has filed 2 cases, 2 affair against me, my lord, and another DB Act. I have filed this application for transfer. That affair I have given since he has.
Your
assaulted.
sole ground for transfer is that you were assaulted.
Yes, sir.
And that has ended in final report.
C belongs to Noyagad, my lord. I belongs to. I am staying at. I belongs to Noyagad. C belongs to Jajpur. Middle. Your lordship, Cuttack or Bhubaneswar, your lordship may transfer. C belongs to my lord Noyagad. Nala Khurda, Bhubaneswar, Cuttack. 2 cases lodged against us, my lord. One 498, another 498. Subsequently, C has been filed since 494 has been added, and DV Act another application. 3 cases. That's why I filed this application for transfer.
ମୁଁ କେବଳ 407 of CRPC ଛଡା କିଛି ଜାଣିନି.
She is working there at Muniguda, my lord.
କିଛି ହବ. ସେ କଣ ଜାଣିନାହାନ୍ତି ଏଟା ହବନି ବୋଲି?
Video conference.
Video conferencing kahinki? You are an accused.
Yes.
Are you not an accused? Yeah, you can. You are not.
498. 2 application has been filed.
No, Mr. Sahu, you are an accused. You don't have to appear every day physically. 317 is always there. 317 is always there. You can seek necessary permission of the court. You can be represented by counsel. 317.
That is there.
But whenever you are required to be, like supposing 313 examination, you have to be there.
Yes.
That's all.
Your lordship, they indicate with that observation, your lordship.
The petitioner, Learned, as directed, Learned State Council has taken instructions that the FIR lodged by the petitioner has ended in final report. The transfer application notice has been served.
No notice was.
No,
there.
Not served. I have served.
On the opposite party.
Yes.
Further, notice on the opposite party There was no direction.
No
No,
direction,
there is no
but
direction, only to take instruction, man. Let notice go, my lord.
Notice has already been served.
always sir.
Notice the service is
Aye, ठीक है, sir.
the state council further submits that notice that the notice of the transfer application. माने कभी hearing हो वो लिखा ही नहीं. This is not a notice of admission. No, it has to be formally go.
I have written
Then
letter
state
that
council
matter is adjourned
is
to
further
17th.
directed to submit to ensure service of notice of the transfer application on the opposite party through the concerned IIC, indicating that the matter shall be taken up for admission on. What did it come? On 22nd October. Interim order to continue. Yes.
Item 35.
अब किसी दिन मची जो था.
Mediation report was also last.
Yes. Final mediation with the failure. The report of the mediator indicates that the mediation between the parties has ended in failure. The transfer application is therefore taken up for hearing. Yes, from Mayurbhanj to Baleswar.
Here what happened, under annexure 1, 2, 3 of the brief lordship, the wife present petitioner initiated 3 proceedings against the husband. This is one is 125 CRPC, another is section 12 of the DBA, another is a criminal case for 90 DM. After this lordship, then annexure 4 lordship is a divorce proceeding initiated by the husband and Moribaj Baripata. Now my place of residence at present lordship, I have a small child having 3 years lordship. My place of residence, my parental house, there is a Nohanjara, another Jaleshwar police station lordship, just so it is difficult in my part to cover
Yes,
the such distance. And I have no other married members. My father has already died and my brother is not there. I'm only single.
Yes, sir. What is it?
My lord, the petitioner is a working legitimate government employee who is working at Mayurbhanj, my lord. He is used to stay there, my lord. That is the
So she seeks transfer of the case from Mayurbhanj to Baleswar.
Baleswar.
That will be against her own interest, isn't it?
Only harassing to the all the cases only to harassing.
Harassing कहेंगे अपन I'll permit you to appear through virtual mode by seeking permission or withdraw court. Allowed transfer application allowed virtual. Yes.
From 36 obligations.
Is the same method? Yes. 36. Yes.
Can I submit with the permission of my senior and
Who am I to permit you?
from your
But
lordship?
the court permits you.
Both I am praying before her because I have to give respect. He is the same.
Very respectful.
Your lordship will remember, I am refreshing your lordship. I have mentioned in my transfer application, both the matter may kindly taken up together.
Yeah, but that has been completed and the judgment is
Judgment. Both the matters have been, my senior also advanced their good. I have also advanced. Your lordship kept the matter for judgment. I could not be able to follow how the senior.
No. Next day he came and made a mention. That is why I wrote it. That
Both the cases,
since
for the
it was-
interest of justice.
Since you are not informed, that is why I have posted it to today. So sufficient opportunity is being given. Don't worry that without behind your back some order.
No, I am not saying so. Where this type of practice.
This
my
is
senior-
backdoor practice. This is known as backdoor practice. You are very fond of it.
Right.
That is what you want to say.
छाड़ो तभी अपन
My lord,
back
the
testing it.
question is matters are not similar. That is filed by his client's mother. There are 2 women are involved. Although in that case, this gentleman is also involved, who is opposite party here. Husband is also involved. So that is why I was opposing, because already they are facing 3 or 4 cases at Rairangu. And your lordship fell from my lord that why don't you go agree for a third place considering that. So that was something ended there. This is a matter, my lord, where this is my husband versus the wife, which your lordship sent it for mediation. Mediation apparently failed in spite of my whatever best foot forward, put the best foot forward, they did not agree. I am very adamant or something, they say my client is.
Your lordship may kind chill. They have filed the. What my learned senior saying so that
ମୁଁ ଦେଖିକି ଦେଲା ପରେ ଦେଇଥିଲି।
ନାଇଁ ଆପଣ ଦେଖିକି ଲେଖିଛନ୍ତି ନା ଏଇ ଲେଖିଛନ୍ତି ମିଡିଏସନ ରିପୋର୍ଟ ଆପଣଙ୍କ କତିରେ ଅଛି ଆପଣ ଲେଖିଛନ୍ତି ଆଫିଡେଭିଟ ରେ
Who affidavit ଦେଇଛି ମୁଁ?
ଆପଣ ଲେଖିଛନ୍ତି The mediation initiated as per the direction of the son of court has failed thus in the seat paragraph 8 टा देखिले आपण affidavit कोन लिखछन्ती आपण affidavit आपण कथा नै
written note.
Huh. Both they have not agreed. Both they have.
Anyway,
That is
we
not
are
the
now
issue.
past. We are now past this because mediation has failed.
Mediation apparently failed.
The only thing is that whether there will be transfer or not.
Transfer or not. This is the husband's. I am against the husband had filed an application before the Hon'Ble court for my lord apparently for divorce. I stayed with my family with my parents at my lord Rairangpur, and there also some other proceedings have been initiated where his client has appeared, filed show cause, and they are contesting the matters. Those details of those cases also have annexed. Not that they are not appearing there. They have appeared there and contesting those cases. Only out of that, only one this case, my lord, the domestic violence case, where my mother-in-law filed an application for transfer. Then again, there are two parts to it. See, he is one of the accused persons, whereas others are there, and they have filed counter. That is there also. So, in view of this, my lord, since it is I am staying there, it is about 300 kilometers difference. It will be difficult for me to prosecute the case at Hon'Ble. So that is why before your lordship. And all the details of the cases I have also annexed. So wife's convenience possibly your lordship would consider, and that has been being followed widely by your lordships and all courts is to be looked at. That is my submission.
That is the law.
That
is the law. Generally, the ladies'
and
convenience
should not be reluctant, my lord, to go there because he is already going there.
All right. Anything, Mr. Das? I'll close it.
Your lordship.
Hearing
One
concluded, judgment.
thing, my lord, I am submitting.
I will judgment reserve for one thing. Kuna di apna 100 things ko to judgment reserve purvur to kaibe.
No, huh. One thing before your lordship, I am submitting, Mr. Lordship. On behalf of the petitioner, the affidavit has been filed. This is the submission of the counsel for the petitioner who is appearing on behalf of. How many cases he has initiated? This is shows the prima facie case that with an evil intention in order to harass and abuse. I am praying before lordship. I am not praying that this matter may be closed. It may be transferred because she is serving a TCS, my lord, Bhuvan sir. Can they deny it?
Yes.
Both the.
I am not serving at Hon'Ble, sir.
So that will be again difficult for her to come to Rairangpur?
No. That for that reason, the petitioner is my wife. As early till today, my wife. I do consider. If she is serving a TCS at Bhuvan sir, my humble prayer before lordship, both the matters may kindly be transferred to the Bhuvan sir. It will convenient for the parties because I have to travel from the. Even
there are other cases. With the case which you have argued,
my lord,
where judgment is reserved. Judgment would have been pronounced, but for this matter.
So for the convenient, even though my mother is there, everybody is there. For no fault they have been.
If both parties agree, I can pass that order. Mr. Solanki.
I am not serving at Bhubaneswar, my lord. That is the absolutely wrong statement. My employers are at Bangalore, my lord. Now I am with my parents and work from home is continuing here.
All right.
The whole statement is
Anyway, I'll consider it.
I am not there in what he said, Infosys, no?
TCS.
TCS, I am not there in TCS either.
All right. Hearing concluded, judgment is out.
37.
SR of notice returned and reported to have been affected by a fixture on front door as the OP had gone somewhere else for his work and the door was also locked. Sam, take.
31 instruction received, my lord. The AC said like this: according to his parents, he is currently residing somewhere in Bangalore. When asked for his current address and mobile number, his parents claimed to be unaware of these details and did not provide any information for communication.
Lord, I am appearing for the.
Yes.
You are appearing for the opposite party?
My senior conducting counsel could not be present.
No, it's all right. It's all right. It's all right. So now that he has appeared at the end of the matter,
Yes.
who's for the petitioner?
My lord.
Yes.
The wife filing the transfer application, my lord.
So what is the name of your senior?
Advocate Badal Kumar Behra.
Badal Kumar Behra. Sri Badal Kumar Behra, advocate. Have you filed your wakalatnama?
It has not.
Yes.
It has not reached the record perhaps, but it has been filed 4 or 5 days back.
All right. Sri Badal Kumar Behra, advocate and associates, have entered appearance for the opposite party. The transfer application is therefore taken up for hearing. Yes.
My lord.
You wanted to be transferred from Balesur to Jajpur.
My lord.
Yes. What is your on what ground?
My lord, the distance is more than 100 kilometers. and the petitioner is residing in her parental house at Jasu, and old and ailing parents, so it's the difficult in her part to reach at a longer distance.
Yes.
My lord, I am praying for one adjournment because my senior could not reach court today due to flood situation in Balisar.
Next week, he seeks an adjournment. Transfer application is taken for hearing. He seeks an adjournment. Let's just matter next week.
38. 38, we have instruction to appear for, we have already appeared, my lord, for the opposite party.
Your lordship, I am for the petition. The previous occasion, my senior appeared before your lordship, and your lordship has given interim protection, and according to the noting, the notice has not been written.
He is appearing, but
Senior
CSK Sodangi advocate and associates have already entered appearance for the opposite party. Yes. Argue.
Lordship, I seek an adjournment short.
Next week.
जवाब दाओ पड़ी पारे तपर होई करे
ना बे जवाब कौन इथरे कौन जवाब ट्रांसफर एप्लीकेशन कौन जवाब को कॉन्स्टिट्यूशनल मैटर हिच ना कौन
Yes, your lordship is here.
Is this matter next week? Is there any interim order? Yes, interim order to continue.
Item 39.
39. सी काई कहउछन त आपण बुझि पाउ नाथि
आगे आपण को प्लीज सर
नहीं प्लीज
नाटा संगे आसीओ
हां the name of Sri SK Sodangi Sudeep Kumar Sodangi, the name of Sri Sudeep Kumar Sodangi be indicated in the cause list. Item 39.
Yes, may please your lordship, I am on the
Both parties have appeared. But there is a mediation report. Let us see.
My lord, I am for the respondent number.
Mediation has failed. Sir, mediation has failed.
My lord.
The report of the mediator indicates that the mediation between the parties has failed. The transfer application is therefore taken up for hearing. Sir, you want it from Bhubaneswar to from Barampur to Bhubaneswar.
Barampur to Bhubaneswar.
Why? Why, sir?
Because the petition is working at some hospital, professional is a doctor, is a busy man, and both parties are interested for divorce, and both are filed separate.
That is what you should have settled. That is why I sent it for mediation.
And that can be settled by mediation, but only financial, basing upon the financial matter, that cannot be possible. For the next negotiation can be.
What negotiation? Negotiation has already failed. How further negotiation next? I will allow the transfer, or I will permit you to appear through virtual board. So I know you are a doctor.
Yes.
Petition is a doctor. My lord, I am a assistant professor in the engineering college. I am having a 3-year child.
Okay. Oh, so
I am for the opposite party.
Okay.
The wife.
Okay. I mean, I will not allow the transfer application, but I'll allow you to appear through virtual board.
My lord.
Transfer application. This is an application for transfer of CP number 5 of 2023 from the Court of Learned Judge Family Court Barampur to the Court of Learned Judge Family Court Bhubaneswar. Even without the order of the court, you can appear through virtual by submitting application. Since you have come, I am giving that order. Otherwise, you don't need order of this High Court. Because we have now, at least in Orissa, everywhere, every court has now had virtual hearing facilities. Almost every court, depending on the net availability. Therefore, transfer has been made on the ground that the petitioner, being a doctor, presently serving in IMS, some hospital Bhubaneswar as assistant professor, it would be difficult on his part to travel to Barampur to attend the court on the dates of posting of the case. Stop. Learned counsel appearing for the opposite party wife opposes the prayer for transfer on the ground that. What are you doing?
I am assistant professor in Parla Maharaja College of Engineering in Bhubaneswar. And I am having a 3-year-old female child, my lord.
Is working as an assistant professor in an engineering college at Barampur. And being a lady, it would be difficult on her being a working lady, it would be difficult on her part to travel from Barampur to Bhubaneswar. Stop. Considering the submissions and taking note of the relative inconvenience that may be caused to the parties, if the proceeding in question is allowed to be transferred, this court is of the view that it would be more inconvenient to the opposite party wife than the petitioner if the proceeding is transferred from Barampur to Bhubaneswar. In such view of the matter, this court is not inclined to allow the prayer for transfer. Stop. The transfer application is dismissed. However, virtual mode. Hello? Virtual. It shall be open to the petitioner to appear through virtual mode by obtaining by seeking necessary permission of the court below. Unless absolutely necessary, physical attendance will not be insisted upon. Yes.
Item number 40.
I please Lordship. Notice was issued.
Yes.
Notice was issued to the opposite party.
Yes. Notice is issued. As per postal tracking report, notice on the opposite party was served on 31/8. Okay. So I had granted one more opportunity. Isn't it? Yes. It has already appeared. I mean, already served. You wanted to be, you are the wife.
But I'm the wife. I'm seeking transfer from Baripada to Baleswar.
Baripada to Baleswar. Why?
The distance is there and
What distance?
it's about 70 kilometers from
No, 56.
65 to 70 around
No.
from her residence.
No.
And the most common place is Baleswar, because from husband's residence to Baleswar court is 25 kilometers and Baripada court is 40 kilometers.
मैं ताको घर ऊपर हिसाब करा हो
मतलब from the
मतलब पिता पकी
address हिसाब रे तो the most common place is Baleswar. Section 9 application has been filed by the husband.
This is section 9 application. All right. So where are you residing?
I'm residing at Baleswar at my parental home.
কোন বড় খিরিপড়া বইসিঙ্গা বইসিঙ্গা is very near to the না না কুরুডা আরে কুরুডা তো is in Baleswar কুরুডা ছক as you enter Baleswar from this side after crossing the railway line level crossing, that is known as kuruda chok.
It is near about 1 and Baripada is like 65 to 50-56.
তাকো ঘর উপরে একদম সে মাপিবে তারপর সেই অনুসারে কনসিডার করা যাব
So the person sees the being the single child and old alien parent.
Allow. Yeah, nuwa kata bismillah.
Item 41.
Item 41.
Was on 13th specifically adjourned to today.
13th कौन था देखिए order last order. There was no appearance probably on the last occasion also.
My lord?
There was probably no
appearance. Yes, my lord. Someone is appearing on our behalf. That
खाली लिखा है ओके चलो पासवर्ड साहब पासवर्ड
42.
देवगुड़ा को complete charge sheet complete very good you just wait so let the diarist come he will seal it after I go through please wait I'm taking up other matters item 43
302 and 34 of IPC read with section 3 of SC/ST PA. Custody sinks 3/1/22.
this is a SC/ST matter
Yes,
So notice has to go probably?
Yes, already.
notice already
Notice already
gone
issued?
and it has been served on 10/9/24.
No, aguru lekha hai bhi hoichi. In the previous order also I have mentioned that notice has been served. Now you have the case diary?
Yes, my lord.
Yes.
Today I have got
I
my
have
lord,
filed the
but your lordship
deposition.
see the last rejection order.
I have filed the deposition.
You are Rakesh Kumar Mahapatra?
Yes.
Yes, your lordship has clearly mentioned.
There was a quarrel between both parties because of demand of Dada Bhatti from the shop of office.
The assault which caused the death of the deceased is attributed to.
Main allegation of assault by knife has been attributed to appellant number 2. I'm not really going to. Yes.
It is there, my lord. Say Dharila, but attributed to that Purna, he has stabbed the deceased, my lord.
So you
But
can.
he has been granted interim bail for 3 months.
Purna.
That's why. No, my lord, present petitioner.
Yes. You have surrendered.
Mine.
You have surrendered to custody.
Yes. After that, I have moved.
No, but what depositions you were referring to?
PW3, your lordship,
PW6
PW3.
method.
The PW3 टा आगे
First
देखो।
PW3, my lord.
Anita Naik.
Yes.
I know the deceased. The occurrence took place 1.5 years ago at about 4:30. On that day, I was returning from Kannu Bela Hotel. I saw the accused persons assaulting Biki Naik, and at that time, accused number 2. Accused number 2 ki?
That Purna, my lord.
Purno stabbed one knife at the right side of the neck of Biki Naik. Then PW6.
PW6.
No, the cross examination रे कौन थी वो?
Cross examination, para 7.
Para 7.
The accused number 2 holding the knife.
I have seen the accused number 2 holding the knife. Okay. Then PW6.
Yes.
I know the informant. And
Purna has been named.
Then accused Purno brought one knife from his cabin and stabbed it on the neck of Vicky due to stabbing also.
But one another eyewitness, Kalu Naik, he has not been examined till date, my lord.
Kalu Naik has not been examined?
No. Paragraph 5,
So,
your lordship has
in view of these two statements, I think they are not implicating the petitioner.
No, my lord, only.
Petitioner can be roped in by 34, with the aid of 34, but the overt act is attributed to that Purno.
Yes.
Yeah. Or the petitioner is in custody since
3/1/22.
3/1/2022. His earlier application for bail. Kete? CRLA number?
CRLA 71522 disposed of on.
715 the 713 of 2022, my God.
Sorry, my God.
Yes, by Justice Honorable Justice Sahu.
Another application is also.
Thereafter, CRLA 967 of 23.
967 रे भी आपण अछंती 967 रे Rakesh Kumar Mahapatra and another. Who is that another? Appellant number 2's application was rejected, one was allowed. That was one was allowed for 3 months. You are Rakesh Kumar Mahapatra?
Yes, I am.
Their appellant number 2 is Purna Chandra Mahapatra.
Petitioner's earlier application for bail was petitioner's earlier application for regular bail was not allowed, but he was granted interim bail for a period of 3 months. The prosecution case is that there was a quarrel between both parties because of demand of Dada Bhatti from the shop of co-accused Purno. When the deceased attempted to assault him by means of a sword, Purno allegedly acted in self-defense and assaulted him by means of a knife, causing fatal injuries. Stop. This court has perused the depositions of the witnesses examined so far in the trial, including the evidence of eyewitnesses Anita Naik, PW3, and
Priti Naik,
Priti Naik.
PW6.
and Priti Naik, bracketed PW6. Both of them have unequivocally implicated co-accused Purno as having stabbed the deceased by means of knife. Stop. There is some evidence, no doubt there is some evidence to show the presence of the petitioner at the spot at the time of occurrence, but then in the absence of any evidence prima facie showing any specific overt act, it cannot be definitely said that the petitioner was responsible for the death of the deceased. Taking into consideration the above facts and the period of detention in custody, I am inclined to allow the prayer for bail. Let the petitioner be released to and so. अच्छा केबे तो custody अच्छी तम लिखी जे? Custody लिखी दियो तो each appearance without representation. Yes. तो रखी जाओ ये को दबो को. हाँ?
Item 44.
May I please, your lordship? My petitioner is in custody, my lord, since 31/3/2022. Who accused your lordship granted bail.
One Ajit Behra, who has last seen the accused person dragging the deceased to the paddy field, he has not been examined. Your lordship said that he has submitted that he is not coming, but he has not been summoned and he is very much available. He is the auto driver. He says that if he will summon, he will go and depose in the court, my lord.
So we will ask, we'll wait till his submission.
No, your lordship, he is not the charge sheeted witness.
Yes, Ajit Behra.
Ajit Behra, right? No, charge sheet witness will the location, the IAC election. Let him be examined.
No, he is not the charge sheeted witness. Your lordship kindly see the charge sheet. Ajit Mishra is the charge sheeted witness. This is the charge sheet, your lordship kindly.
କେତେଟା ଅଛି?
पूरा अच्छी भाग एक नंबर रू देली नेक्स्ट पेज
Accused person ମାନଙ୍କର ଆପଣ ଦେଇଛନ୍ତି।
ଆଜ୍ଞା ସମସ୍ତଙ୍କର ଚାର୍ଜ ସିଟ୍ ଟା ଦେଇଛି।
ନାଇଁ ମୁଁ
He is not the charge sheeted witness.
particulars of the witnesses to be examined ଏଇଠି ଅଛନ୍ତି। ସୁକାନ୍ତ ଗୌଡ଼, ପ୍ରଶାନ୍ତ ମିଶ୍ର, ସୀମାଞ୍ଚଳ ସେଠୀ, ଶ୍ରୀକାନ୍ତ ପାତ୍ର, ଅଜିତ ଆଚାର୍ଯ୍ୟ, ଅଜିତ କୁମାର ମିଶ୍ର, ନବକୃଷ୍ଣ ଦାସ, ଅଖିଳ ନାୟକ, ବିରଞ୍ଚି ନାୟକ, ହରିହର ପାତ୍ର, ଗଣେଶ ଆଚାର୍ଯ୍ୟ, ସୁଖଦେବ ନାହାକ, ପ୍ରଣତି ନାୟକ, ଡକ୍ଟର ଆଶିଷ କୁମାର ଶୁକ୍ଳ, ଟୁଟୁ ପାତ୍ର, ସମୀର କୁମାର ଭୂୟାଁ, ଜିତେନ୍ଦ୍ର କୁମାର ମଲ୍ଲିକ। ଟୋଟାଲ ତ 21 ଆଉ ଇଏ କଣ ହବ? ଇଏ ତ ନା ନାହିଁ, ଅଜିତ ବେହେରା ନା ନାହିଁ।
He has not submitted last time.
କଣ not submitted?
ତମେ କହିଲେ ସେ ଆସୁନି, summons ଦେଲେ repeatedly he has been summoned and he is not coming. Your lordship directed to take instruction, my lord.
No, I have simply said. One of the charge sheet witnesses on whose version the prosecution relies upon has not been turning up to depose the evidence. Hey.
That is Ajit Mishra.
ଆପଣ ନାଁ ଆମେ ଲେଖା ହେଇନି। So you go through this charge sheet.
My lord, I have charge sheet.
You have the charge sheet.
Yes.
So you have to then clarify.
Yes, my lord.
Follow, sir.
Apart from that, there is allegation.
So that is a different matter. I will take up the application. I will take up tomorrow.
Yes, ma'am. Yes.
Place this matter tomorrow. ये तक भरी दियो सारटा ये ऐसे मैटर टा देलो 42 मैटर टा
Item 42.
yes से ये टा दियो खाली Charge sheet submitted. ଚୁରେ କାଟୁଛ ତ ଶୁଣ ମେସିନ୍ ଲାଗିବା ପାଇଁ ହେଇଛି ସିଲଟା କଲାବେଳେ ଲାଗିବନି କି ତଳୁ ଇଏ କରି କରିବାକୁ ପଡ଼ିବ। ଦେଇଦିଅ ସେ ଦେବ ଖୋଲିଦବ। ଦେଇଦିଅ ଦେବକୁ ଦେଇଦିଅ। So 3 persons. The particulars of accused persons 1, 2, and 3.
We are not.
अच्छा टॉयलेट से 3B Samal, Additional Superintendent of Police, CBI, ACB Bhubaneswar appears in person and submits a report in the sealed cover. The sealed cover is opened in the open court and the report is perused. It transpires from the report that after completion of investigation, charge sheet has been submitted in the Court of Learned Special CJM, CBI Bhubaneswar on 31/8/2024. Stop. A copy of the charge sheet has been enclosed to the report. Stop. Since charge sheet has already been submitted, no further order is required to be passed by this court in the matter, as it is for the concerned court to proceed further in the matter in accordance with law. The report of Sri Samal is kept in a sealed cover, kept in a cover which is sealed in the open court in his presence. Said report said sealed cover be handed over to Registrar Judicial for safe custody. The matter is treated as closed. Further appearance of Sri Samal before this court is not necessary. Just wait for a moment, it will be received. So, आपको पैकेट चिरीगला से आउट पैकेट करते हैं. आउट मैटर नहीं जो कौन बोला था. 45 था देखिए
Only 50 is the modification of the order.
item
50 টা modification of the order.
item 50 what modification
Blood court number টা ভুল ଆଉ ତାପରେ 697 in lordship's order that is 697 ହେଇଯାଇଛି 691 ହବ.
item 50 ରେ correction be carried out accordingly any such small matter item 51 item 51 ରେ
item number 9
item 51 ରେ 51 ରେ কি ଦେଇଛନ୍ତି letter आगे extension of time item 51 से appear करो देखिए yes
item number 9 item number 9 19 and 21 my lord these are the three passover items in item number 9 my lord I was directed to obtain the instructions also the records though I have received the instructions but I have not received the records because today that 17th my lord the supervisor on so this matter will be taken up 1 week after my lord so that I can produce the
item 9
item number 9
you are there
yes
there are parted matter
parted matter
heard further in part place this matter on
May I pardon my lord?
May I be 1st October
May I be pardon my lord?
Item number 48, my lord.
no, there are two other matters sir?
Yes, item number 19, my lord. That was also passed over, but on 6/9, my lord, we have received a parawise comment and we'll file the counter.
Item 19, list this matter on 29th October. Counter will be filed in the meantime.
Another 21.
21.
Where Mr. Roth is there, my lord.
Yes.
There, my lord, we have received a consolidated writ. And on the last occasion also, my lord, we had taken the time to file the reply to the consolidated prayer, consolidated writ petition, my lord. Though I have contacted them, my lord, but I have yet to receive the documents, my lord. So another 2 weeks.
As requested by Leonard State Council, is this matter on 22nd October. Yes, Mr. Mayor.
Item 48, my lord.
Opposite party number 5 was appointed. My lord, take a note of last date, my lord. 5 my lord, interim order was there, my lord. In spite of that, OP 5 was appointed. So record was called for, my lord.
Record is there.
It's sorted.
Short date कर दो
8th October.
8th October.
May I pardon
Yes,
my
my lord.
lord?
Item number 48, my lord. My lord, I have a specific matter fixed at 2 p.m. in the court of Honorable Chief Justice.
Yes.
Can it be taken up now or tomorrow, my lord?
Tomorrow now, on Mukhyan, what is that?
Tomorrow.
Item number 45, my lord.
Only for extension.
Extension was first time it has come. 2 weeks.
Item number 45, my lord. The matter may be taken up next week, my lord.
45 next week.
46.
Yes.
Next week, my lord, 1 week after that crime branch matter. So that IO is out of station.
1 week after good date. First October. Yes.
46 on basis of Mohan madam. Interim extension of interim bail madam. We lots of granted.
No, that let me take up. Ashijaw Dokao. Mr. Samar, thank you. Thank you for your cooperation. Otherwise, it will not be proper, huh?
Item number 46.
This is on where Mr. Sashikanta Mishra. Petition filed for extension of the interim order granted in the lawsuit granted on 29/4/2024, my lord. Democracy was granted interim bail.
Okay, then.
Yes. That's it.
Considering the submissions. The prayer for extension of interim bail is allowed. The interim bail granted by order dated 29/4/2024 is extended for a further period of 2 months. No. Yes.
Item 47.
Here I am in custody.
Yes.
Since 26
9/20/21 million. And
You are
in the
required to
mean-
file the, you are required to file the, I mean, the consolidated bail application along with copies of depositions.
That I have already filed.
Depositions you filed?
Depositions on the last occasion, your lordship said that keep it so that it can be filed on the next day.
Yes. You are Shamsher Khan. Earlier, did you approach this court earlier?
No. The first time.
Yes.
Co-accused is Lords may look at the FIR.
FIR, yes.
Page 6. FIR is by an eyewitness, brother of the deceased.
He says, Munna Kumar Saha.
Named certain persons. Sixth line. दो गाड़ी में मुश्ताक, आमिर, मुख्तार, अरमान, नौशाद और साथ में अनजाने एक लड़का आया.
You are not one of these
I'm
people.
not named in the
Yes.
No allegation of myself having committed any specific overtime.
Charge sheet has been submitted?
Yes, that's it. Trial has commenced.
Okay. Oh, sorry, I'm so sorry.
Out of the 15 witnesses who have been examined so far, I have not been implicated by anybody.
Who are the main witnesses?
My lords may see.
These are all official witnesses.
Yes, there are witnesses are there also.
PW 13, 14 and 15.
14 and 15.
PW 13 is this Abhiraj Kumar.
Abhiraj Kumar.
He turned hostile.
Yes, he turned hostile. Now, PW 14 has given some evidence, my lords, but he has also not named. He has named Amir, Mustaq and Arman.
Any other witnesses?
The PW 15 minutes has turned hostile.
PW 15 also turned hostile.
So far as I am concerned, 15 the last.
He has been implicated on the confessional statement of co-accused and the statement recorded of other co-accused under section 27. And my lord, one wife of the deceased, Nutan Deep, though she has not identified the accused persons, but in the TI parade, she has correctly identified those accused persons. This present petitioner.
Including the petitioner.
Including the petitioner.
Yes.
So let her be examined.
Yes, what is it?
That is there, madam.
Let her be
And nothing, and for antecedents, that is of 380. No.
My submission is, my lord, I am in custody now since 21.
No, but in any case, prima facie, you appear to have a good case in as much as there's only a confessional statement, as it appears, as you
Yes,
have
madam.
very
Yes,
fairly
madam.
pointed out.
My only implication is she has stated omnibussly, my lord, that so and so were.
No, but in TI parade, if she has identified
She
you,
has identified.
Lord, she may see the TI parade report.
Yes, ma'am.
There also she doesn't disclose any overtime.
sir, 161 टा व्यवहार करो.
161 का मत place करो.
Let me just go. नीति लिखो जाते हैं.
Okay, AW. I have got eligible.
No, see, because of the form, I cannot blame our officer.
My copy is more.
जगह होने से पूरा
ऐसे- in this case that the above named suspects on the alleged date of occurrence and time had fired bullets and attacked the deceased. How many guns how many weapons were recovered?
Weapons,
Amir Khan.
Amir Khan, other witness in the forwarding report also chopper, gun.
Bujali and other things.
Bujali and other.
No firearm has been recovered, except from Amir.
Yes. So please place a
Statement is ମୋ ନାମ ନୂତନ ଦୀପ ବୟସ 27 ସ୍ୱାମୀ ସୋ ଏଣ୍ଡ ସୋ ମୁଁ ରିମଝିମ ବସ୍ତି ରେଲୱେ କଲୋନୀରେ ନିଜ ପରିବାର ସହ ରହେ ଆଜି 12/9/21 ଆପଣଙ୍କ ନିକଟରେ ମୋ ଦେବାର ମୌଖିକ ବୟାନ ନେଇକି ଯେ ମୋ ସ୍ୱାମୀ ଗୋରେ ଓରଫ ଜିତେନ୍ଦ୍ର ଶାହ 10/9/21 ସନ୍ଧ୍ୟା ସମୟ 6:50ରୁ 7ଟା ସମୟରେ ଆମ ଘର ପାଖରେ ଛିଡ଼ା ହୋଇଥିଲେ। Now Gore and his brother Munna, they are accused in the FIR filed by Amir, where this fellow is also a witness relating to the murder of his brother Dilsad in 2020. ମୋ ଦେଢଶୁର ମୁନ୍ନା ଶାହ ତାଙ୍କ ପାଖରେ ଓ କିଛି ଦୂରରେ ହିମାଂଶୁ ଓ ସୁରଜ ମାହାତ ଠିଆ ହୋଇଥିଲେ। ଏଟା ହେଲା PW 14 ଆଉ 15। ମୁଁ ସେତେବେଳେ ଆମ ଘର ଭିତରେ ଥିଲି। ହଠାତ୍ ମୋ ସ୍ୱାମୀ ଛିଡ଼ା ହୋଇଥିବା ସ୍ଥାନରୁ ଧୋ କରି ଆବାଜ ହେଲା। ମୁଁ ମୋ ମାଉସୀ ଲକ୍ଷ୍ମୀ ଓ ଘରର ଅନ୍ୟମାନେ ବାହାରକୁ ଆସି ଦେଖିଲୁ ଦେଢଶୁର ମୁନ୍ନା ଦୌଡ଼ି ଆସି କହିଲେ କିଛି ଲୋକ ମୋ ସ୍ୱାମୀ ଗୋରେଙ୍କୁ ଗୁଳି ମାରୁଛନ୍ତି, ଅସ୍ତ୍ର ଦ୍ୱାରା ଆକ୍ରମଣ କରୁଛନ୍ତି। ସେ ସମୟରେ ଗୋଟେ ଗୁଳି ଆସି ମୋ ମାଉସୀ ଲକ୍ଷ୍ମୀ ଦେବୀର ଗୋଡ଼ରେ ବାଜିଲା। ମୁଁ ସିଆଡ଼କୁ ଦୌଡ଼ି ଯାଇ ଦେଖିଲି 9ରୁ 10 ଜଣ ଲୋକ ମୋ ସ୍ୱାମୀକୁ ବନ୍ଧୁକ, ଚାପଡ଼, ଭୁଜାଲି ଇତ୍ୟାଦି ଅସ୍ତ୍ରରେ ଆଣୁଛନ୍ତି ଓ ଗୁଳି ମାରୁଛନ୍ତି। ମୁଁ ଯେତେବେଳେ ମୋ ସ୍ୱାମୀଙ୍କ ପାଖକୁ ଯାଇ ଦେଖିଲି ମୋ ସ୍ୱାମୀ ଜିତେନ୍ଦ୍ର ଓରଫ ଗୋରେ ରକ୍ତାକ୍ତ ଅବସ୍ଥାରେ ତଳେ ପଡ଼ିଥିଲେ। 3-4 ଜଣ ପିଲା ପିସ୍ତଲ ଓ ଚାପଡ଼ ଧରି ଛିଡ଼ା ହୋଇଥିଲେ। ଯେତେବେଳେ ଏ ଘଟଣା ହେଲା ସେତେବେଳେ ଘଟଣାସ୍ଥଳରେ ଷ୍ଟ୍ରିଟ୍ ଲାଇଟ୍ ଜଳୁଥିଲା। ସବୁ କିଛି ଭଲ ଭାବରେ ଦେଖାଯାଉଥିଲା। ମୋ ଦେଢଶୁର ଅନ୍ୟମାନେ ସେଠାରେ ପହଞ୍ଚିବା ପରେ ମୋ ସ୍ୱାମୀକୁ ମାରୁଥିବା ଲୋକେ ରେଲୱେ ଲାଇନ୍ ଆଡ଼କୁ ଦୌଡ଼ି ପଳାଇଲେ। ତାପରେ ମୋ ଦେଢଶୁର ମୁନ୍ନା ହିମାଂଶୁ ସୁରଜ ମାହାତଙ୍କ ସହାୟତାରେ ଗୁରୁତର ଅବସ୍ଥାରେ ଗୌତମର ଡାଲା ଅଟୋରେ IGH ସେକ୍ଟର 19 ହସ୍ପିଟାଲକୁ ନେଲେ। କିଛି ସମୟ ପରେ ମୁଁ ଜାଣିବାକୁ ପାଇଲି ମୋ ସ୍ୱାମୀଙ୍କର ମୃତ୍ୟୁ ହୋଇଛି। ମୋ ସ୍ୱାମୀକୁ ହସ୍ପିଟାଲ ନେଉଥିବା ସମୟରେ ତାଙ୍କର ପୁରା ହୋସ ଥିଲା। ସେ ମୋ ଦେଢଶୁର ମୁନ୍ନାକୁ କହିଲେ ତାଙ୍କୁ ଅମୀର, ମୁସ୍ତାକ, ନୌସାଦ ଓ ତାଙ୍କ ସାଥୀମାନେ ମିଶିକରି ମାରିଛନ୍ତି ବୋଲି କହିଲେ। ତାଙ୍କ କହିଥିବା ସବୁ କଥା ମୋ ଦେଢଶୁର ତାଙ୍କ ମୋବାଇଲରେ ରେକର୍ଡ କଲେ। ମୋ ସ୍ୱାମୀଙ୍କୁ ଯେଉଁମାନେ ଗୁଳି ଫୁଟେଇ ଓ ହାଣିକିରି ମାରିଥିଲେ ସେମାନେ ହେଉଛନ୍ତି ମୁସ୍ତାକ, ଆମିର, ମୁଖତାର, ଅରମାନ, ନୌସାଦ, ଡେକ୍ଚି, ଫୁକୁନି, ଲାଲୁଆ, that is the petitioner, ଅରବାଜ, DJ ମନୁ ଏବଂ ସୋହେଲ। ସେମାନଙ୍କୁ ଦେଖିଲେ ମୁଁ ଚିହ୍ନି ପାରିବି, କାରଣ ଘଟଣାଟି ଯେଉଁ ଜାଗାରେ ହେଲା ସେ ଜାଗା ପାଖରେ ଆଲୁଅ ଥିଲା। ମୁଁ ସେମାନଙ୍କୁ ପାଖରୁ ଦେଖିଛି। ମୋ ସ୍ୱାମୀ ପୂର୍ବରୁ ଦିଲସାଦ ଖାଁ ମର୍ଡର କେସରେ ଆରେଷ୍ଟ ହୋଇଥିଲେ। ତେଣୁ ଦିଲସାଦର ଭାଇ ଆମିର ଓ ନୌସାଦ ଏବଂ ତାଙ୍କ ଲୋକମାନେ ମୋ ସ୍ୱାମୀକୁ ଜୀବନରୁ ମାରିଦେବାକୁ ଚେଷ୍ଟା କରୁଥିଲେ ବୋଲି ପୂର୍ବରୁ ମୋ ସ୍ୱାମୀଙ୍କ ଠାରୁ ଜାଣିଥିଲି। ତେଣୁ ମୋ ସ୍ୱାମୀ ବେଶୀ ସମୟ ଘରେ ରହୁଥିଲେ। ମୋ ସ୍ୱାମୀଙ୍କୁ ମୁସ୍ତାକ, ଅମୀର, ମୁଖତାର, ଅରମାନ, ନୌସାଦ, ଡେକ୍ଚି, ଫୁକୁନି, ଲାଲୁଆ, ଅରବାଜ, DJ ମନୁ ଓ ସୋହେଲ ମିଶି ହତ୍ୟା କରିଥିଲେ। 10ରେ ଇନସିଡେଣ୍ଟ ହେଲା। ସି ଇଜ ଏକ୍ସାମିନ୍ଡ ଅନ୍ ବାର 12।
How many gunshot injuries?
PW3 is the doctor.
Yes, that is what I saw.
PW5 is the doctor.
PW5, sir.
Yes, sir.
Dr. Sunil Bhengra, Justin Sunil Bhengra. He has noticed
3
gunshot wounds, my lords. 3 gunshot wounds. 4 gunshot wounds. All from distance shots.
And 16 inside zones.
There is only one thing. She was inside the house.
Yes.
Hearing the sound, she came out.
Came out.
And she also says that I've seen so many people assaulting my husband. Then she says that while
They had
being
fallen down.
carried away to the carried to the hospital, her husband disclosed the names of the
Disclose the
assailants.
name and this
But
present
three names.
petitioner's name finds there, madam.
No.
Now, yeah, after that,
ମୋ ସ୍ୱାମୀ କହିଲେ ତିନିଟା ନା କହିଲେ ଆମିର
ତିନିଟା ନା ତାପରେ
ଏବଂ ଅନ୍ୟମାନେ
yes.
ଇଏ ଯୋଡ଼ିଛନ୍ତି ତା ଦେହରେ ଇଏ ଯୋଡ଼ିଛନ୍ତି ଦେଖନ୍ତୁ ଆଉ ଥରେ ପଢିଲେ ସେ ଜାଗା
ହେଲା ସେ କହିଲା
ମୋର ସ୍ୱାମୀକୁ ଯେମାନେ ଗୁଳି କଲେ
ହସ୍ପିଟାଲ ନେଉଥିବା ସମୟରେ ତାଙ୍କର ପୁରା ହୋସ ଥିଲା ସେ ମୋ ଦେଢଶୁର ମୁନାଙ୍କୁ କହିଲେ ତାଙ୍କୁ ଅମୀର ମୁସ୍ତାକ ନୌସାଦ ଓ ତାଙ୍କ ସାଥୀମାନେ ତାଙ୍କ କହିଥିବା ସବୁ କଥାକୁ ଦେଢଶୁର ମୋବାଇଲରେ ରେକର୍ଡ କଲେ
ମୋ ସ୍ୱାମୀକୁ ଯେଉଁମାନେ ଗୁଳି କରିଛନ୍ତି that certain other names that present
she is supplying those names she is supplying those names isn't it he may have been present there but now had there been any other evidence to show that he was also involved in the assault
no that is not there and that Lakshmi Devi who is injured that Bhauja I think and she has also not identified and she has also not put to TI parade. Only the wife of the deceased she has been told for TI parade.
The petitioner is in custody since 26/9/2021 in connection with such and such case. The prosecution case is that while the deceased
deceased Jitendra Shah alias
Gore alias Jitendra Shah was standing near his house along with his friend
and brother
Munna Kumar Shah and two friends
informant
along with his friends and brother several persons named in the FIR came to the spot in two vehicles
into two-wheelers
two vehicles in two motorcycles being armed with guns and other deadly weapons. They fired at the deceased and also severely assaulted him by means of the deadly weapons, causing grievous injuries on his person. While being shifted to the hospital, the deceased gave out some of the names of some of the assailants. And subsequently, he succumbed to his injuries. On completion of investigation, charge sheet has been submitted against Kejano.
It has been submitted against
7 persons, including the present petition. The Devashish Panda, learned counsel for the petitioner, submits that the petitioner has not been named in the FIR. The FIR as well as other police papers specifically mention the names of the co-accused persons.
10 persons have been
10 persons. Charge sheet is here. Names of the co-accused persons, but the petitioner's name does not find place therein. Moreover, none of the witnesses examined so far have implicated the petitioner. But Learned State Council has opposed the prayer for bail by submitting that the petitioner was one of the assailants and was correctly identified by the wife of the deceased who had seen the occurrence. After considering these submissions and on going through the materials on record, including the depositions of the witnesses, bracket PW1 to PW15, the TI parade report, this court finds that one of the eyewitnesses
that is
Himanshu
no,
14.
Period 14 बोले नहीं
Himanshu Chakravarti.
that one Himanshu
Chakravarti alias Kesri.
Chakravarti bracket period 14 has described the occurrence in vivid details, but he has not specifically named the petition as being one of the assailants. It further appears that period 15 for along
15 days of
that the other eyewitnesses, namely
13 and
PW 13 and 15, turned hostile. Though the petitioner appears to have been identified correctly by the wife of the deceased, yet in the absence of any connecting material to show his presence at the spot or of any overt act being attributed to him, it is difficult to prima facie rely solely on such evidence. So this is being said for all the more reason that the wife of the deceased, in her statement recorded under section 161 of CRPC, has referred to the so-called dying declaration of her husband before his brother, which was recorded by his brother, wherein he has named only 3 persons as having assaulted him, while saying that others were also involved. The petitioner's implication appears to be on the basis of his own confession and the disclosure statements of the co-accused persons recorded under section 27 of the Evidence Act. সেটা বদলে দিউন তো 27 টা তার corresponding section বচালে আমি কই দিই
नहीं 27 দাও
Justice Mahapatra may say, Justice Mahapatra or whoever is dealing with fresh bail matters may say, I am blank completely, I don't know anything about it. Why can't you? Thus, from a conspectus of the discussion made above, this court finds that there is that prima facie there is a lack of acceptable evidence to show the complicity of the petitioner in the alleged occurrence. Thus, taking into consideration all the above facts and the period of detention of the petitioner in custody, I am inclined to allow the prayer for bail. Let the petitioner be released. Such and such condition, including the condition that he shall personally appear before the. Has it been committed?
The trial is going on.
Sorry, I keep on forgetting.
I'll appear on each date of the trial.
Without representation. He shall appear before the trial court on each date of posting of the case, and no representation through counsel shall be allowed under any circumstances. Yes.
Some exceptional circumstance may arise. Lord, can I take back the certified copies?
Please.
Right. Urgent copy.
Urgent copy. Why urgent copy?
Thanare bhi appear karu. All of them having criminal antecedents, my lord. Gangsters. All are gangsters.
Both sides have
Wife ka examine hai nahi.
लिखित he shall not threaten, coerce, pressurize, or otherwise influence the prosecution witnesses in any manner. In any case, even if that lady is examined, yes.
Item 49.
Maybe
48.
এটা কেতে গলা 48 গলা 47 48 আরজন নিছে 48 yes.
Petitioner is in custody, my lord, more than 3 years. 21C of the NDPS Act. 1 kg 55 gram has been seized. Yes. Wife illness, your lordship
1
grant
kg कौन
brown sugar.
সেটা কও না সেটাକୁ ଉହେ ରଖିବାକୁ ସବୁ କହୁଛନ୍ତି
Illness of wife, I have moved before the court below. Bail was refused.
you are ମାନେ asking for interim bail no
For
not in
no bail ପାଇଁ କହିଛି interim bail your lordship consider.
file
Yes, day after tomorrow. Friday asu in the meantime.
ଏଇଟା ବି ଆମ ଛୁଟିରେ ରହିବି ଆଜ୍ଞା next week ଆସ
Next week.
ଆସ you file list this matter next week as well
So item number 31.
oh ସରିଗଲା ଏଟା 31 31 କଣ ଇଏ ପାସ ମୁଁ ଦେଇଥିଲା
May I please, my lord?
31
My lord, the petitioner is Raurkela family court was ordered to ex parte. The petitioner now staying at Balangir, my lord, with her parents, and he has a small son. So she prayed to transfer Balangir family court.
where is it pending
My lord,
where is it pending
Raurkela family court.
no. You want it to be transferred to
Balangir.
yes
My lords, the ex parte orders is allow 25/2011, my lords, is not set aside, my lords. My lords, annexure 4 of the petition, my lords, 24/4/23 orders, my lords, kindly see. Only limitations.
so this petition has not been allowed
My lord,
so an ex parte order was passed
yes, my lord.
so that has not been set aside
But my lord, she can't reach to the court because it's 310 kilometers, and her son was a small child, so, and her parents were old, and she's very
no
poor.
this application let this application be considered let some order be passed thereafter we'll keep it pending unless this application this was କେବେକୁ ରହିଛି ଏ matter 25/4 ଥିଲା ତାପରେ କଣ ହେଲା what is the present status of the case the court below is directed to transmit the status of the case for information of this court lest this matter
1st October.
on 1st October this order be communicated to the court below forthwith yes
So item 41.
That the interim extension of interim bail. That Firoz Khan case.
yes what happened
What happened, your lordship, like kindly say, I don't have that file because someone has taken my file.
somebody has taken away your brief
ସେଇଟାରେ lordship pancreatitis ତାର cholesterol ଇଏ ସବୁ ହେଇ doctor
granted him 2 months
food and your lordship food and ପାଣି ଟା ଟିକେ ଜଗିଦେଲେ 15 ଦିନ 20 ଦିନ ବି ଦେଇଦେଲେ ଟିକେ survive କରିଯିବ
ବହୁତ ହେଇଛି ଆଉ ହବ ବହୁତ ହେଇଛି ଏଇ କେସ୍ ରେ I have granted him ହବ
yes your lordship
ତେଣୁ ହବ
ବର୍ଷେ
either
ଖଣ୍ଡେ ହବ interim bail
ଆପଣ ରିଜେକ୍ଟ କରିବେ ଯାହା ଏଇ ଦିଟା ଭିତରୁ ଯାହା ହବ
at least 15 days
ନା 15 hours ବି ହବନି 15 hours ବି ହବନି I not pressed yes ବଢିଆ ରିଲିଫ ଅର୍ଡର ପାଇଲେ ଆପଣ ବହୁତ ଭଲ ଅର୍ଡର ପାଇଲେ କାରଣ ରିଜେକ୍ଟ ହେଇଥାନ୍ତା yes ସରିଗଲା
Sir.
ଦେଖ
Quickly list item number 1, matter.
I had the matter, my lord, directed to take instruction, my lord. I have sent the registered letter, it was returned, my lord, and not answer. Address is left, my lord.
what is it? The return answer
Address is not found. Input as well.
so this is a case where that appeal had abated
No, not abated. It has been dismissed as against the respondent number 4. So the entire appeal should be dismissed because the decree is not agreeable.
I have circulated the suit.
but an order has to be passed to that effect this court must first hold that it is not severable and therefore the appeal will dismiss all right I'll close it hi Raksha I may pass a small order, may not be a big judgment.
Your lordship will pass the
Or right now should be passed. Let us see the decree. Okay. This is an appeal against a confirming judgment. Or a reversing.
Reversing. My suit is allowed in favor of me.
So you are the plaintiff.
Yes, ma'am.
appeal was allowed.
Appeal ଆପଣଙ୍କର allowed.
My
More suit.
it is a reversing judgment.
Reversing
ma'am.
judgment.
Reversing judgment, yes. Appeal.
Suit for specific performance of contract.
I am unable to find the trial court judgment. Yes, there is. What was the decree, sir? What was the decree? The suit was decreed पर कौन इतना? Is part against defendant number 1 to 5
Execute the sale deed in favor of me.
and expert against defendant number 4, but without cause it is hereby declared that the registered agreement dated at the executed between defendant number 1 and plaintiff for the suit land is valid agreement, which is specifically enforceable. Declared the registered sale deed executed by defendant number 1 and 3 in favor of defendant number 4 is an illegal document. Defendant number so between defendant number 1 and 3 in favor of defendant number 4 was an illegal one. One is directed to execute a defendant. So this was reversed. What was the finding of the appellate court?
Finding of the appellate court, my lord, defendant number 1 is 1/3 co-sharer. He is the son and it is joint family property. In the joint family property, defendant number 1, 2 and 3 all are 1/3 share each. Defendant number 1 executed the agreement in the personal capacity, not as the Karta of the family. Second was so far as area is concerned, out of the total plot of 90 decimal, it has been executed the agreement for northeast corner. But the boundary was given for the entire plot. The defendant number 4 has purchased the northern half of the plot. So the half of the property does not include in that agreement.
It cannot be severed.
That is, the defendant has not delivered possession.
No, I am looking at the trial court's order. It says that the suit is dismissed on contest against defendant number 2 and 5 and expert against defendant number 4. The suit is decreed in part on contest against defendant number 1 with cost. You are defendant number 1.
I am also defendant.
Defendant number 1 is directed to defend a sum of rupees to the plaintiff. Yes, Ardo. This is an appeal by the plaintiff against a reversing judgment passed by learned additional district judge, fast track court number 3, Bhubaneswar, on 11/10/2022, followed by decree in title appeal number 2/8/14 of 2002-2001, whereby the judgment passed by learned Civil Judge Senior Division Bhubaneswar on 11/6/2001, followed by decree in TS number 222 of 1985 was reversed. The suit was filed by the plaintiff for specific performance of contract. The suit property related to the land tenant.
All plot number 556. All plot number 556.
Let me just find.
ଆମେ ଦେଖିକି ଏଥର ଦେଖିବା କଣ କରିବା ବିଲକୁଲ ହଉନି ଆଉ ଆମେ ସେଥିରେ ଦେଖିଲା ବେଳକୁ ଆଗ ରେସ୍ପଣ୍ଡେଣ୍ଟ ର ବାହାରିଲାଣି the plaintiff decided to purchase a piece of the plaintiff's case is that he decided to purchase a piece of land at Bhubaneswar. The defendants 1 to 3 proposed to sell the suit property for which they entered into negotiation with the plaintiff. The price of the property was fixed at rupees 10,000. And on receipt of rupees 1,500 towards part payment of consideration, defendant number 1, as Karta of the family, executed a registered agreement in favor of the plaintiff to the effect that they would sell the suit property on or before 10/7/1984. The plaintiff was ready and willing to pay the balance consideration money and regularly contacted the defendants to execute the sale deed. But the defendants allegedly deferred the execution on some plea or the other. Some plea or the other. In the meantime, the plaintiff came to know that the defendant number 1 and 3 had already executed a registered sale deed in favor of defendant number 4 in respect of the suit land. Falsely making certain false representations regarding the suit land in the said sale deed. So, it is the further case of the plaintiff that defendant number 4 was never put in possession of the suit land. On such facts, the plaintiff filed the suit for specific performance along with incidental release. Defendant number 4, being the purchaser, did not contest the suit and was set ex parte. The other defendants entered appearance and contested the suit by filing written statement. They inter alia took the plea that defendant number 1 was not the karta of the family and had no authority to execute the agreement in favor of the plaintiff. The said agreement is a fraudulent one, and there was no payment of advance by the plaintiff as claimed. Since there was a dissension among the heirs of the plaintiff's family, her husband, being close to defendant number 1, instigated him to execute the impugned agreement in favor of his wife, bracketed plaintiff, only to pressurize defendant numbers 2 and 3 to disclaim any share on the suit property. It is their further case the defendant number four is a bona fide purchaser of the suit land. On the basis of a registered sale deed dated 11/9/1985, on payment of consideration of rupees 7,000, followed by delivery of possession.
Pardon?
Followed by delivery of possession.
You, defendant number 5 is in possession.
Sir, wait. Further, defendant number 4 sold the suit property to defendant number 5 under registered sale deed dated 1/11/1985, accompanied by delivery of possession. Basing on such pleadings, the trial court framed the following issues for determination. Basing on the oral and documentary evidence adduced by the parties, the trial court accepted the case of the plaintiff as claimed and decreed the suit against defendant numbers 1, 2, and 5 on contest, and ex parte against defendant number 4. So, the registered agreement dated 13/7/1983 executed between defendant number 1 and the plaintiff relating to the suit land was held to be a valid agreement and specifically enforceable. So, the registered sale deed executed by defendant numbers 1 and 3 in favor of defendant number 4 was held to be an illegal document. Accordingly, defendant number 1 was directed to execute a registered sale deed in favor of the plaintiff in relation to the suit land within 3 months on receipt of balance consideration. Similarly, defendant number 5 was directed to render vacant possession of the suit land in favor of the plaintiff on the date of execution of the sale deed. Further, defendant numbers 4 and 5 were also permanently injuncted from interfering with the possession of the plaintiff in respect of the suit land. Being agreed, defendant numbers 1, 2, and 5 carried the matter in appeal. The First Appellate Court, after considering the oral and documentary evidence independently and the position of law, held that the plaintiff had not approached the court with clean hands to get equitable relief. It was further held that though she had contracted with defendant number 1, she unjustly desired specific performance of the contract through all the 3 co-sharers. Further, noting that the suit land had been sold by defendant numbers 1 and 3 in favor of defendant number 4 and subsequently by
defendant number 4 in favor of defendant number 5 for value, comma, the first appellate court held, for value, comma, the first appellate court held that the plaintiff is not entitled to any relief except compensation. Accordingly, the appeal was allowed. The suit was dismissed on contest against defendant numbers 2 and 5 and ex parte against defendant number 4. Defendant number 1 was directed to refund a sum of rupees 1,500 to the plaintiff with interest. Being further agreed, the plaintiff has filed the present second appeal, which was admitted on the following substantial question of law. It is order dated 21/2004. Heard Sri B.K. Mahanti, learned counsel for the plaintiff appellant, and Sri A.N. Rautrai, learned counsel appearing for all the defendants.
Defendant 1 and 3. Yes,
जो
sir.
मैंने appeal करता
Sorry, 3 is died, my lord. 1, 2 and 5.
for the defendant respondent numbers 1, 2, and 5. So, at the outset, Sri Rautrai submits that as per order dated 18/6/2024, passed by this court, the appeal has been dismissed as against respondent number 4 for not filing requisites as directed by this court for more than 19 years. For more than 19 years. Wait. He further submits that in view of dismissal of the appeal against respondent number 4, no further relief can be granted to the plaintiff since the decree cannot be severed. Stop. Sri Mahanti, learned counsel appearing for the plaintiff appellant, does not dispute the position that on dismissal of the appeal against defendant number 4, the decree becomes the appeal cannot be continued only against the other defendants. Stop. Correct. After hearing learned counsel for the parties and on going through the decree passed by the First Appellate Court as reversed, First Appellate Court in reversing the original decree passed by the trial court, this court observes that as per the impugned decree, the suit was dismissed against defendant numbers 2 and 5 and ex parte against defendant number 4. The suit was decreed on contest against defendant number 1 with direction to refund rupees 1,500 to the plaintiff. Stop. As has already been narrated here and before,
Equity आता जमला वो कहीं
yeah,
जमला equity आता ना 1,500 my lord I am to pay my lord that I will pay.
no, let me complete the order. Let me complete the order.
Yes.
Yes. Before, defendant number 4 was the purchaser. Defendant number, the suit land was sold to defendant number 4 on the basis of a sale deed for value, and possession was also delivered.
it is also the common ground. It is also accepted by the parties that defendant number 4 resold the same property to defendant number 5 and delivered possession. Stop. In such view of the matter, in the absence of defendant number 4, because of dismissal of the appeal against him, it is obvious that the decree cannot be severed. For which the appeal cannot continue in respect of against the other defendants. So, in such view of the matter, this court observes that nothing further remains to be decided in the appeal, which is therefore dismissed. The order passed, the judgment and decree passed by the first appellate court is hereby confirmed now. Yes. That's all. ଏଇଟା ପାଠାଟା ନବ ନା ପାଠାଟା ସରିଲା ପରେ ଯିବା ଆଉ. Yes.
Item number 2.
Anything else you wanted to be written? କଣ ଆଉ ଚାହୁଁଥିଲେ କଣ?
1500 ଟଙ୍କା ତ ଫେରି
ଆଜ୍ଞା ଜଜମେଣ୍ଟ ଟା କହିଲି କନଫର୍ମ କଲି, ସେ ଜଜମେଣ୍ଟ ଟା 1500 ଲେଖାଇଛି, ମୁଁ ଆଉଥରେ କିଏ ଲିଖିବି? କନଫର୍ମ କରିଦେଲି, ସେ ଫେରେଇ ଦେବେ ଆପଣଙ୍କୁ. That direction is always there. ଆଉ ଗୋଟେ ହେଇଗଲା.
May I please your lordship?
Item 2, yes.
My lord, Bhavanipatnam Municipality is the appellant before your lordship. My lord, the present respondent is plaintiff, my lord. Your lordship has already had this matter, had in part matter. Before the Civil Judge Junior Division Bhavanipatna, my lord, filed a civil suit praying for injunction restraining the Bhavanipatnam Municipality to not to interfere in the peaceful position of the plaintiff and not to collect rents, and to declare that the Bhavanipatnam Municipality has no right, title and interest upon the suit land and the house standing thereon, and further to declare that the earlier decree passed by the Learned Civil Judge Senior Division Bhavanipatna in TS number 4 of 19...
Mr. Nanda, wait. LCRSG.
My lord.
LCR. Achida? Huh?
Sir.
All right. Yes, continue.
My lord. That is, earlier decree passed by the Learned Civil Judge Senior Division Bhavanipatna in TS number 4 of 1973 is null and void, and it is not binding upon him. That earlier suit was between Bhavanipatnam Municipality as plaintiff and his father, my lord, as defendant. It was the case of the plaintiff that his father was a teacher in Brajamohan High School, and from the year 1951, he continued in possessing the suit house, resided therein, and after his death, the present plaintiff, my lord, respondent before your lordship, is continuing in possession of the house. This earlier suit filed by the Bhavanipatnam Municipality, my lord, that was decreed in favor of Bhavanipatnam Municipality for recovery of possession, and that was passed by the Learned Civil Judge Senior Division Bhavanipatna. And the suit plot, my lord, it was which belonged to the ex-ruler of Kalahandi, and after merger, my lord, it has been recorded in the name of the state of Odisha under Exhibit 1 as Sarvasadaran. Thereafter, my lord, it is the contention of the plaintiff that, and his father, my lord, his father did not challenge the earlier decree in any forum, my lord, neither before the district judge, not any forum. And after, my lord, on the pleadings, and we also filed the written statement stating that this is not maintainable, as he has filed the suit before the Learned Civil Judge Junior Division Bhavanipatna, with a prayer that the decree passed by the Learned Civil Judge Senior Division Bhavanipatna is null and void and not binding upon him. As such, this suit is not maintainable. And as he has also sought for declaration, and yet he has not made the state of Odisha as a necessary party, therefore the suit is also bad for non-joinder of necessary party. And third matter, the suit of the plaintiff is hit by the law of res judicata, because it has already been decided between the father of the present plaintiff and the Bhavani Patna municipality, and it is the claim of the plaintiff that he stepped into the shoes of his father, and thereafter he is possessing the land. The Land and Trial Court may not frame as many as 10 issues and answered all the issues against the plaintiff and declared that he has fell on all grounds and may not dismiss the suit. Thereafter, the present respondent plaintiff, he carried an appeal before the Land and District Judge. The appeal was allowed. The Land and District Judge has stated that the suit is not hit by res judicata. And second, the present plaintiff, my lord, he has a better title than Bhavani Patna municipality. And accordingly, my lord, he allowed the appeal. Thereafter, challenging the Land and First Appellate Court judgment and decree, the Bhavani Patna municipality is before your lordship. While admitting the appeal, my lord, on 9/1/2019, this honorable court was pleased to frame two substantial questions. 9/1/2019, whether the learned First Appellate Court has committed grave error in law, giving a finding that the plaintiff has better right and title over the suit house than that of the defendant when he has not disputed the finality of the judgment and decree passed by the Learned Civil Judge Senior Division Bhavani Patna in case number 4 of 19. The court was pleased to dispose of the writ application, directing that if he files appropriate application and before the Tahsildar under OGLS Act, as it is a piece of government land, it will be open for the state authority to take a decision whether it can be settled or not. That is the only issues, my lord. And your lordship, if you will see, my lord, the First Appellate Court judgment, it is totally vitiated, my lord, from page 10.
No, let us first go to the trial court's judgment.
My lord. Trial court's judgment, my lord, your lordship may kindly see.
How did he enter upon the suit land? On what basis?
His father, my lord. His father had entered.
In what capacity?
My lord, it was a force
No, whatever. But what was he doing it? What is that property?
Teacher and it was his pleading.
No, what is that property?
Property, my lord, it was a club. My lord, the ex-ruler of the Patna state, he has given an, my lord, a registered deed, my lord, deed of
ex-ruler of Patna or Kalahandi?
Kalahandi, my lord. Sorry, Kalahandi. It was a Wheeler Club, my lord. Wheeler Club, and that PKDO ex-ruler, my lord, the deed of assignment was executed in favor of the Bhavani Patna municipality. But later on, my lord, in the current settlement operation, which was completed in the year 1964-65 in Kalahandi, and the suit land came to be recorded in the name of the state of Orissa, and the Kisam was Sarvasadhara.
So it is just a, is it a podia?
But a house is there, my lord.
Oh, it is a house.
House
constructed by?
Constructed by ex-ruler, my lord.
So that house was being occupied by the plaintiff?
Plaintiff, my lord.
Yes.
It was Wheeler Club. Wheeler Club.
Anyway, according to you, it was a forcible occupation.
Forcible occupation.
Right.
That's why we filed an earlier suit for recovery of possession.
So that suit was decreed?
Decreed in our favor.
Yes. And delivery of possession was granted?
Granted.
And you never executed that decree?
It was, no execution was filed. But he also did not challenge the same decree in any higher form, and it has attained its finality.
All right. What will be the effect of non-execution of the decree may not nullify the effect of the decree. That's a different matter. But fact remains that you never executed that decree.
No execution was.
Now, on what basis was this suit filed? What was the relief claim? To disturb the peaceful possession of the plaintiff. They are going to declare that the defendant has gone over. What was the cause of action? Cause
of action? We are disturbing in the peaceful possession of the plaintiff. We are claiming rent on behalf of the Bhavani Patna municipality. This was the claim, and he also made a specific prayer was made to declare the earlier decree as null and void and not binding upon him. And one type of negative declaration that the Bhavani Patna municipality does not have right, title, and interest and possession over the suit land, and Bhavani Patna municipality be restrained from disturbing in the peaceful possession of the plaintiff. These threefold prayer were there, my lord, in the plaint.
So the suit was
dismissed, my lord, by the Land Trial Court.
By holding that he does not have any right title
interest, and the Bhavani Patna municipality, he cannot be restrained from entering into the suit land and from collecting rent, and the earlier decree is binding on him.
All right. So what happened in the appeal?
In appeal, my lord, they your lordship may kindly see the page 12, my lord. Page 12 of the internal page 12 of the Learned First Appellate Court's judgment.
Yes.
Paragraph 12, my lord.
Yes.
Regarding operation of the principle of res judicata, I am of the considered opinion that in the earlier suit, TS number 4 of 1973, the status of the parties were different, whereas the status of the parties to the present suit are different. To add to this, the basis of claim of the present plaintiff in this suit being somewhat independent than the basis of claim of his father in the earlier suit, the finding in the earlier suit, TS number 4 of 1973, cannot operate as res judicata to the present suit. And my lord, earlier pages, your lordship may kindly say page 10 and 11.
Yes.
Page 10, my lord, last paragraph. In absence of any material showing transfer of the suit house by
Page 10 row.
Page internal page 10. My lord.
There is no last paragraph.
My lord, last, sorry, my lord. The last 1, 2, 3, 6, last 9, 10 lines, my lord.
What is the word?
Similarly, from similarly.
Similarly, yes.
Similarly, the present plaintiff has never been ousted from possession of the suit house and till now is continuing its possession. So, in view of such factual position relating to possession of the suit house and in absence of any material showing transfer of the suit house by the true owner, state of Odisha, in favor of the municipality, it cannot be said the municipality has a better title than that of the present plaintiff joint over the suit house. In such situation, the plaintiff has every right to protect his possession over the suit house until evicted in due process of law by the true owner. My above view is countenanced by the decision of our Honorable High Court in case of Ratan Garai versus Hiralal Ram dead. After him is Alars, Srimati Priti Prabha Lahiri and others reported in volume 119, 2015, CLT 201. Accordingly, it is held that the plaintiff has got a better right title than that of the defendant institution in respect of the suit house. And in next page, my lord, he has held that earlier decree is not binding on the plaintiff. Though it was a specific pleading of the plaintiff that he entered into the shoes of his father, shoes of the father, and after the death of the father, he continued in possession. And also declaration cannot be, my lord, sought for without implementing the state of Odisha as a necessary party, because after the current settlement operation, that originally belonged to the ruler of the ex-ruler of the Kalandi state, it was a Wheeler Club.
Was there any note of possession in his favor or an illegal note of possession in the current settlement ROR?
No, my lord.
You have the current settlement ROR with you? Was
Yes,
it
my lord, it is in Exhibit 1, my lord.
Exhibit 1. What was there? What was mentioned?
Exhibit 1.
It was, I mean,
Sarva Sadharana.
No note of possession.
Note of possession is not there.
All right. So that is your case.
My lord.
This is your case.
My lord.
Anything else?
My lord, while answering the substantial question of law, I, my lord, respectfully submit that the earlier decree is binding on the parties because it was between the father of the present plaintiff and Bhawanipatnam municipality, and the suit itself is, my lord, not maintainable because a prayer has been made. There is an hierarchy before the Land and Civil Judge Junior Division to declare that the decree passed by the Land and Civil Judge Senior Division is not binding on the plaintiff and it should be declared as non-void. And second, my lord, at the state of Odisha has not been made a necessary party because after the current settlement in the year 1964,
you have already said that.
My lord. And third also, my lord, with great respect, my lord, the plaintiff has not able to show that with greater measure the grave in error in finding by the last appellate court, first appellate court, that the plaintiff has a better title. And second, my lord, the suit is not hit by the principle of res judicata.
Yes. Why are you using this, sir, on your head? Any problem?
Your mother's request, so totally have taken out. Hello. In the last occasion, your lordship had put a question relating to TS case 4/74, 73. Your lordship, there are three things are there in this title suit, which has been very much referred and has been in the order, in the interim judgment and decree. Number one is the decree passed in 1975 neither is being executed nor being challenged. The second one, your lordship, it is infractious and unperceivable. And the third one is that, but it has not lost its validity. And the fourth one, your lordship, it still holds good and binding. These were four findings that the learned appellate court below stated in the judgment and decree, your lordship. My case is that I have been in the suit house, which has been in the Sabok ROR, the plot number, it is written Rosai Ghara, your lordship. It's a house. It belonged to ex-ruler. And since 1951, I was a teacher next to that house. Therefore, I possessed it.
You or your father?
My father. My father possessed it, who expired in 2001, your lordship. And it was a house, still it remains to be a house. But in the Prajakhana, it is written Sarvasada, after the recorded, after the settlement. My lord, why I am here? When I was possessing this, until today it is about 70 years, I have been, after my father, I have been in that house. And when repeatedly municipality gave me the notice, in 2005, I filed an application before the Tahsildar for settling that piece of land and house in favor of me. While
Only on the basis of long possession. Obviously.
Landless, that was jealous because of land settlement. I don't have land, being a landless person. So, after my father died in 2001, I applied before the appropriate authority, competent authority, that is Tahsildar, who is the true owner of the land, to settle the suit house in favor of me. While my application was pending, in 2000.
Mr. Kuntia, you are waiting for the next item.
Next item.
We'll take it up tomorrow. Because I'll take up the orders matters. Tomorrow we'll take it up. After this matter will be over today. Tomorrow we'll take it. Please, is the other side here, Mr. Sahu? Mr. Sahu will take it up tomorrow. First matter. These two matters are over today. So, tomorrow. Yes, please. Please continue.
In 2001, in 2008, the appellant, they gave me the notices, eviction notices, but not the execution order by the court. And since it was illegal, that the notices were not in
No, I remember now. I had asked you on the last occasion to apprise the court about the legal position. Now that decree stares at you. It has not been enforced or executed. So what will be the effect of non-execution of a decree?
So
does it become automatically nullified by the efflux of time? So that you have to answer.
My lord, I have prepared for that. The answer is
yes.
Specifically, the lordship also had the specific question to me. Here there is a situation, your lordship. There is a judgment and decree, but there is no judgment debtor. There is a decree holder, but the decree is there. The holder has lost his authority to execute the decree. That's the situation.
Why?
Because of the 12 years limitation, the decree holder cannot go to the.
That is what I'm saying. You please refer to the Limitation Act now.
The limitation, according to the Limitation Act, Section 12.
Yes.
It is barred by limitation.
Kete article kete?
12. Sorry.
Article 136.
Yes, 136. Article 136.
So now,
Now,
this is what will be the effect of this Article 136? So he cannot enforce it anymore.
yes, ma'am.
So it becomes a non-enforceable decree,
Yes, ma'am.
non-executable decree.
Yes, ma'am.
So argue it from that angle. That is what I said yesterday
ma'am.
on the last occasion.
Yes, ma'am. And I'd like to also refer to section 2 of CPC. Who is a judge, section 210, who is a judgment debtor? A judgment debtor means any person against whom a decree has been passed or an order capable of execution has been made. That means it was passed against my father. And there is no scope for any successor or legal representative against whom it would be binding. The person whom should have been bound is no more. And the holder who should be binding, he is barred by the limitation. In such situation, learned court below, I mean the appellate court, what the judgment it has been passed in the decree, I'd like to present that.
Yes.
Your Lordship, page number 12, para 13.
Yes.
To sum up on careful reappraisal of the evidence on record with a touchstone of settled position of law, it is found that the findings on all the issues and the ultimate verdict of the learned court below are erroneous.
You know, this is just he's just
And the
finding.
last one is important. At the same time, it is found that the plaintiff is entitled for a decree of perpetual injunction against the defendant until he is evicted from possession of the suit house by the true owner in due process of law. That is the case. I will be evicted not by the municipality, but I will be only evicted by the state of Orissa. That is my case, number one. And why I didn't make state as a party to this case, what the appellant they are claiming. Your Lordship, the plaintiff is the master of suit. And the cause of action against whom will be there, only the person or the person whom I will be taking the relief, I will be making the party. In that case, the respondent is, my client is not challenging or asking for any title. It is the title, the true owner is the state of Orissa, for whom a separate application is there. And then on the basis of the law, what this honorable court already has directed, already it has been decided, where it has been directed that.
Let us see that order.
Yes,
that read petition order.
Read petition.
File.
It is tagged.
No, it is there. It is tagged.
It is tagged, madam.
It is tagged there. Can you please place the
Is made a response while annexure 4. Whatever notice they had given to me, I replied in annexure 4, Your Lordship, and denying ownership of the municipality. While the consideration of the request of the petitioner was pending, the municipal authority has issued the notice while annexure 5. Status quo was given, status quo order was given to that, thereby directing the eviction of the petitioner on the premises of his illegal occupation of the municipality property while annexure 5. Considering the submission of Learned Counsel for the petitioner and from annexure 4, this court since finds there is a fight over the disputed property both by the petitioner and the municipality. The read petition remains unentertainable. If the petitioner so advised, he may approach the competent authority. At this stage, Learned Counsel for the petitioner submits that is me, ventilating his grievance, the petitioner has already approached the Tahsildar Bhavani Patna opposite party number 3 by annexure 2. In the event, the representation at the instance of the petitioner while annexure 2 is pending with the Tahsildar Bhavani Patna opposite party number 3, the same may be disposed of in accordance with the law and by giving opportunity of hearing to the petition.
what happened
It is still pending, Your Lordship.
since 2019?
Yes, ma'am. So the application is still pending.
Okay.
So I am claiming title or to record the suit land in favor of me. Therefore, my application is pending before the true owner of the suit land. Now,
You have the Limitation Act with you.
no,
Okay. Article 136 of proviso the because your claim, your suit was not for title, but it was for perpetual injunction or permanent injunction.
Yes.
You see, there's a proviso. 136.
my
There's no limitation for execution of such a decree. ମାର୍ଥର ସେଥିପାଇଁ କହିଥିଲି ଆପଣ ଟିକେ ସେଇ ଲାଇଟରେ ଟିକେ ରିସର୍ଚ୍ଚ କରିକି ଜଜମେଣ୍ଟ ଫଜମେଣ୍ଟ ଟିକେ ଖୋଜନ୍ତୁ। ହଁ ହଁ I will ବୁଝିପାରିଲେ ତ? Your suit was never for title.
Yes.
You may have come said that you could have come saying that ମୁଁ ଏତେ ଦିନ ରହିଲିଣି I have acquired title by way of adverse possession. That would have been different. Your suit was plain and simple for injunction. Or to restrain the Bhavani Patna municipality from evicting you from the, or to interfere with your possession. There is no, such a decree carries no limitation as per the proviso. Proviso
Yeah, provided that an application for the enforcement or execution of a decree granting perpetual injunction shall not be subject to any period of limitation. So now the point is the true owner.
So you examine it. You examine it. What will be the effect? So in such a situation, can you ignore the previous decree? You see, it is not only the true owner, parties or persons litigating under them. There you will come into the picture. You being the son of your father, and you are claiming possession straight from 1951.
Yes, ma'am.
Entire plain story is that.
Yes, but I will come back to some of the things.
Take.
How the
Take it,
settled
take it.
possession, how the settled possession is giving right.
No, these
for
are the facts.
permanent
No, sir. These are the facts.
Fine.
These are the facts. So you have to build up your case
Yes.
around your facts.
So,
Because you are claiming possession right from 1951 when your father was there, not you. Your father had entered into the suit house or suit property, whatever. So that was in 1951. So you are claiming under your father.
yes,
So now to come forward and say that the original judgment letter is not there, he has died, you can't take that plea. It will be blowing hot and cold.
my lord, this is the submission. Yeah.
I'm just pointing it out to you so that you can be in a better position to assess the court. All right.
Fine.
Heard further arguments in part. Is this matter next week? How many?
23rd, my lord.
I'm a boy for
Sorry, my lord.
On 23rd.
My lord.
Obliged.
And you also prepare.
My lord.
Hmm?
My lord.
How can you enforce that decree now?
My lord.
You have to read the plaint.
My lord.
ମୁଁ ତ ପ୍ଲେଣ୍ଟଟା ପାଇଲିନି ଆପଣ ଖୋଜନ୍ତୁ ପ୍ଲେଣ୍ଟଟା। What was the decree passed in that suit? What was his claim? And he obviously could not have claimed title.
My lord.
And he never claimed title.
My lord.
He only claimed permanent injunction.
My lord.
If it is permanent injunction, no limitation is there.
My lord.
Privacy.
My lord.
I may be wrong
And
again.
Lanet trial court, my lord, he has my lord, made a prayer that Bhavani Patna municipality doesn't have a title. So Lanet trial court has given a finding that if I am go to the factum of title, then the true owner is a necessary party. Because how can I decide it is the state has the title or municipality has the title or the plaintiff has a title?
All right.
And that's what is a specific finding that this suit is bad for non-joint.
No, this is a very interesting but subtle point, but you find out.
My lord, one thing is there in the appellant court's order that I was trying to touch into the adverse possession side, but in the meantime, I have dropped that. That part also has been reflected.
All right. Yes, item 4.
Obliged.
I don't know 4 for orders.
But hard in part.
Part hard is data আছে আগোটা আছে 23 Yes, orders matter.
Item 4.
Requisites file করনা থে।
In fact, there has been a gross mistake, I say, because
Dismiss कर दो आपको।
2006. No, any.
2006 ରେ ହବନି।
3 ଜଣଙ୍କ ଉପରେ ମାତ୍ର
2006 ରେ ହବନି ଡିକ୍ରି ସେଭରେବଲ ନେଇ ପାରିବନି ଆଇଟମ 1 ରେ ଯେମିତି ଅର୍ଡରଟା ପାସ୍ କରି ସେମିତି ହବ।
ତା ଦେହରେ କଣ ହେଇଛି?
Mr. Mahathi, you have seen me passing similar orders. I cannot condone.
Dispense with the notice.
ୟାଙ୍କ କେସରେ ତ ହେଲାନି ଆପଣ ୟାଙ୍କ କେସରେ ଡିସପେନ୍ସ
Notice dava ପାଇଁ
ତାହେଲେ
ନବା ପାଇଁ ଦେଇଛି
2006 ରୁ ହେଲେ
2006 ରୁ there has been a କେମିତି ସେଟା ମିସ୍ କରିଛୁ ଆମେ ଅର୍ଡର ସିଟ୍ ବି ମେଣ୍ଟେନ୍ ହେଇପାରିନି ସେଟା ଏନି ଏକ୍ସପିଡିସନ୍ସ ୱେରେ ନହେଲେ ବି ମୁଁ ପ୍ରିପେୟାର୍ଡ ଅଛି ଗୋଟିଏ କ୍ୱେଶ୍ଚନ ଅଫ୍ ଲ ସେଟା apparently there has been mistake
whether in absence of pleading and non-framing of relevant issues has prejudicial effect to the plaintiff
ସେଇଟା ନୁହଁ
the concept of co-personary and co-personary property can be taken resort to after Hindu Succession Act co-personary property ପଳେଇଲା Hindu Succession Act amendment ରେ
ନାଇଁ ନାଇଁ ଗୋଟେ property sale ହେଇଛି one of the co-personers have sold the property others are there. Now even the Supreme Court has come to a conclusion that the sale will remain valid to the extent of the sale. That has not been considered. That is the only question. Other findings are in favor of the plaintiff.
so who are 34 and 35
34, 35, they are the
33 and 34
contesting parties. That is all the issues are in favor of the plaintiff. Sale is valid, for consideration paid, everything is there. Only ground is that the other co-sharers are there. Therefore, the sale is invalid. That
So
is the only ground.
on 33 34 and 35
Yes.
you were directed to take notice in the year 2006
That is why I have seen the order sheet. Because in my records is not there. That's why I went through the order sheet.
no I am looking at the order
Yes, I have seen just now. I have seen the order.
so କେତେ ବର୍ଷ ହେଲା
Around 18.
18 years या पूर्व मैटर टा जो कली से 19 years ହେଇଥିଲା ବୋଲି ତାକୁ dismiss କରିଥିଲି against those I will have to dismiss it ସମସ୍ତଙ୍କ ପାଇଁ ଗୋଟେ order ହବ
ଗୋଟେ opportunity ଦେଲେ ମୁଁ ନେଇ
ତାକୁ opportunity କଣ ତାକୁ ତ ଦେଇନି ଆପଣ କେମିତି
ମୁଁ କହୁଛି the merit of the appeal is there. That's why. Only one question. Any cost heଲେ I am prepared to be.
cost ତ ହେଇପାରିବ କିଛି ମନା ନାହିଁ but the bar will then say that the court is favoring Mr. Mahathi.
Favoring.
I don't want to take that risk, sir. Let the bar say that I'm a bad judge, I will accept it. But to say that I'm favoring somebody, you will be very, very unacceptable. Hobble. This court directed notice to be, sir, it is even hour earlier, 6/10/2004 20 ବର୍ଷ ହେଇଗଲା notice ହେଇଥିଲା 6/10/2004
ହଁ ଲାଷ୍ଟ ଡେଟ୍ ହଉଛି 11/8/2006
no ସେଟା ତ ପରେ it was time
ନା ସେଇଦିନ exemption ହେଲା exemption ହେଇକରି 8/5/2006 it was listed
3 to 32 and 36 to 41 was dispensed. So 33 to 35 remains. So that notice was directed to be issued first time on 6/10/2004. And thereafter you have never taken time. No time was granted. So that is the date. Notice on respondents including.
2006 ରେ ଗୋଟେ order ହେଇଛି ବୋଧେ
No, ତାପରେ ତ order number 5 ହେଲା 11/8/2006. Call this matter 1 week after as prayed for by counsel for the parties.
ହଁ ସେଇଥିରେ noting ଥିଲା noting ଅଛି ଦିଆ ହେଇନି ବୋଲି
noting ଟା ଅଛି ନା voting office note ଲେଖିছে ନା ଦିଆ ହେଇନି ବୋଲି 2006 ରେ was Justice PC Mishra there?
JP Mishra.
Oh, sorry. I'm so sorry. Justice JP Mishra. All right. So the no time was granted.
ସେଇଥିପାଇଁ order ହେଇଛି
Notice କଣ ଲେଖିଲେ ହବନି to be issued to respondents to be issued by order dated 6/10/2024. Notice on respondent numbers 3 to 32 and 36 to 41 was dispensed with. As such, notice was required to be served on to be issued to respondent numbers 33 to 35. 20 years have passed in the meantime. The requisites have not been filed. This court finds no reason to grant any further time for the purpose. The appeal is therefore dismissed as against respondent numbers 33 to 35.
33 to 35.
Yes. If it is, if you can't prove that the decree can be severable, then the entire appeal will go up.
ସେଟା ମୁଁ ଦେଖିଦେବି 1 and 2 ଅଛନ୍ତି
So there's a list this matter for hearing on kepe go to week in the week commencing 21st October. Yes.
Item 5. On item 5, no, in noting matter, the noting such matter, 80 not back from.
Author fresh notice नहीं जाता. It is not back. See, you 30 दिन आए करी कि हमें करी दी परिवा, but you take fresh notice. At least these matters were not are being taken up now. So let him have notice. All right. Issue fresh notice to respondent numbers, to all the respondents.
Yes.
To respondent numbers 1 to 6. Anybody else has appeared? How many respondents?
1 to 6.
Issue fresh notice to the respondents by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days.
That somebody appear in the.
In the meeting, respondent 1 and 3 have entered appearance. So fresh notice be issued to respondent number 2, 4, 5 and 6. Is this matter on?
28th October.
In the week commencing 28th October. Yes.
Item 6.
This matter, the suit scheduled lands, have already been sold off to one Arya Construction, who in turn sold it off to my company, the petitioners. They have not been included as parties. We just came because the managing director of the company is suffering from cancer. So he was under this treatment, so the documents I will get within a week.
You want to intervene?
We want to intervene.
Intervene, you have to file an application for implement.
Yes, ma'am.
Isn't it?
I'll file an application.
Who's for the petition appellant?
My lord, I am appearing for the appellant.
No, you cannot appear for appellant. Sir, appellant is dead.
Okay.
Sole appellant is dead.
He has not been substituted?
No. So he cannot appear for appellant.
Substitution pending.
Substitution application is pending. We'll send notice.
Sir, applications for substitution has been filed by 2 imposters, claiming to be the wife and son. The person died unmarried.
Sir, we will do one thing. We'll issue notice. You can file your objection, or you want to file your objection?
Filing objection today, in fact.
Today?
I'm filing the legal aid certificate.
ठीक है, legal aid certificate file. हम copy दोगे ना?
Manufactured documents. An inquiry is required if at all they file some prima facie material. Filing objection, there should be here the matter.
Okay. So आइए हला कोड़ा आगे कोई ले?
Substitution.
हाँ सही substitution number ओड़ा कौन?
IA30.
Sir? 301.
301 of 2020. Substitution.
IA 301 of 2024.
Bad habit. File a case.
You are appearing. You are Mr. Agarwal. Huh? Mr. Ramesh Agarwal. Abhishek. There is another Agarwal. Ramesh
Yes, Ramesh Agarwal.
Yes. Sri Abhishek Agarwal. You file your objection or you want to file?
Yes, already filed.
Has filed objection. Sri Abhishek Agarwal, who is appearing for? Respondent. Sole respondent.
Respondent about that file different.
Prepare करिए you must assist your senior.
Respondent number 1.
The appearing for respondent number 1 has filed objection in court after serving copy on the counsel for the appellant. Learned counsel for the appellant files copy of legal heir certificate of the proposed legal heirs of the deceased appellant. Same be kept on record. So this matter we can take it up for hearing when? I will. Let me finish this.
Yes.
301. Yes.
So a question of intervention at this stage may not arise.
No, but this matter, let us.
Till this is decided,
question of intervention will not arise.
May not arise. So that will be, we'll keep it pending. We'll
Yes,
keep it
my
pending.
lord.
they have to
Because my lords, I apprised your lordships that he is suffering from cancer, so he was under.
I will take note of your submission and
Yes,
saying
my
that you
lord.
want to
And I
file.
will file an application by next week. Let it come up someday.
We'll take it up for this first. Let this IA 301 be heard.
Right.
My lord.
Because since he is raising an objection
Yes,
and which appears to have some basis,
my lord.
then because what will happen is since he has produced a legal certificate, then again that has to go for verification also. Scrutiny, obviously.
Yes.
Because he is disputing that also.
Yes, my lord. And in the meantime, be it as it may, my lords, the entire title of the land has been transferred to me.
But it cannot be, this is a lispendence.
Not lispendence.
Yes.
92 it was transferred prior to the suit.
We'll hear it.
Yes, my lords.
We'll hear it. It requires
It
hearing.
was transferred.
Prior to the suit, if it is transferred, he cannot intervene. He has to file a separate suit.
No, I don't know exactly. That is why I need all the documents.
All right. List this matter on Puja Purvurkurti.
7th October.
In the week commencing 7th October.
Well, sir.
No, 7th October is for this hearing of this IA.
My lords, prior to 7th October, the other week, my lords, 8th, I'll be going off.
30th September. 30th September.
30th September.
In the week commencing 30th September.
Yes.
So who's your associate?
Mr. Ajit Das.
Ajit Das.
Ajit Kumar
Raut.
Ajit Kumar Raut. Sri Ajit Kumar Raut appears and submits that he has instructions to appear on behalf of
No, nobody is there.
Golden Land
He
Developers.
has to file intervention application.
I'll file a
he would file an intervention application on behalf of one of the purchasers of the land. I've said one of the purchasers of the land.
Yes.
I've not said when you have purchased it.
My presence may be recorded.
That's all. Sri Milan Kanango, Learned Senior Counsel, has been engaged by Sri Raut.
At least his interest is protected.
Yes. What interest I have not said.
Another intervention application 1430.
No, you are appearing for him.
No, madam, that is all the.
Without.
I am for 1430 intervenor. I have filed there. It is for.
That is already on
That
record.
will be considered at the time of hearing. Let it be regularized.
Yes.
Right.
All right, item 7.
Not 7.
I am the respondent, my lord.
Yes,
I mean,
usually. AD of limitation between issued and Revan 7A.
my lord, kindly see.
Respondent 1A and B. I am appealing for respondent 1A.
1A and B. 1 and 2 is 1A and B.
How would he appear?
In 7, my lord.
You are appearing for respondent number 1A.
No, no,
My
no.
lord,
No, 7. Item 7. Next item. Yes.
item 7, I am the respondent, my lord. My
The
lord,
respondent
kindly
1A
see
ରେ appear କରୁଛନ୍ତି କି ଆପଣ? Yes.
1A.
The postal tracking report shows that notice on respondent number 7 bracket A small a has already been served. You are appearing.
My lord,
I am for appellant.
Wait. Again,
my lord, 7 already expert ହେଇଯାଇଛନ୍ତି. 7 expert ହେଇଛନ୍ତି trial court ରୁ. ଆଉ
ହେଲା,
23
ଠିକ ଅଛି. There is however no appearance. Learned counsel for the appellant is present. Counsel for the other respondents are also present. You are appearing for the other respondents.
I am for respondent number 1, my lord.
Only one. What about the
No,
other
no.
respondents?
ଅନ୍ୟମାନେ କିଏ ସମସ୍ତେ expert ହେଇଯାଇଛନ୍ତି. ଜଣଙ୍କୁ ଛାଡିକିରି ଆଉ ସମସ୍ତେ expert
ନାଇଁ, ଅନ୍ୟମାନେ
ହେଇଯାଇଛନ୍ତି.
ସବୁ ହେଇଯାଇଛନ୍ତି.
ହଁ, expert ହେଇଯାଇଛନ୍ତି.
ଆଜ୍ଞା ତଳ କୋର୍ଟରେ ହେଇଥିଲେ ଏଠି ସମସ୍ତେ appear କରିଛନ୍ତି ଆଜ୍ଞା ସମସ୍ତଙ୍କୁ ନୋଟିସ
ନା, ନା. ନାଇଁ ଆଜ୍ଞା, କେହି appear କରୁନାହାନ୍ତି.
appear କେହି କରିନାହାନ୍ତି but notice sufficient ହେଇଛି.
ହଁ, ହଁ.
Regularize ତ କରିବା ସେ matter all right. So now this is on the limitation matter notice had gone.
My lord, my lord, my lord. Huh.
Nobody has appeared for notice has been delivered on respondent number 7A and others they were already served as noted by Justice Behra in his previous order. So only respondent number 7A was required to be served and he has already been served. There is no appearance. Other respondent 1 is present. So how many days delay? Miss case
My
kete?
lord, delay is 4 years. 4 years.
Medical certificate is filing.
No, my lord.
ଟିକେ ସେ ଆଜ୍ଞା କହିସାରନ୍ତୁ ଆପଣ ଟିକେ କହିସାରନ୍ତୁ
File medical certificate my lord.
Sir?
File medical certificate for condonation of delay my lord.
କାହିଁ ସେଟା ମିସ୍ କେସ୍ ଟା କେତେ କହୁନାହାନ୍ତି ଆଜ୍ଞା
This case number 5.
How many days delay? SR is 1246. Yes. What is the matter involved, Koili? What is the point involved?
The matter suit was for practitioner, but
You are the plaintiff or the defendant?
we are for plaintiff.
Yes. What happened? যদি appeal କିଛି ଥିବ ମସଲା ତାହେଲେ ଆମେ consider କରିବା delay ନହେଲେ
First appeal भी आगे सही limitation ground पे discuss.
ଆଜ୍ଞା ଆପଣ ଟିକେ ରହିବେ
हाँ.
Miss Mishra, why are you so worried? I don't understand.
Sorry, my lord.
My lord, କାଲି ଟିକେ ଆସନ୍ତୁ, my lord and senior ରହିଲା.
All right. Pass over for the day. ଏତିକି ଯାହା ଲେଖା ହେଇଛି କାଲି ଅର୍ଡରଟା ହବ କଣ ତାପରେ ଆମେ ଲିମିଟେସନ ପିଟିସନ ଦବା. Yes.
Item number 8 of
Orders କେତେଟା ଅଛି? Orders please.
Please, Lordship, on behalf of Mr. Devashish Tripathi.
ଆପଣ ଏପଟକୁ ପଳେଇ ଆସୁଛନ୍ତି ମିଷ୍ଟର ଗୟା from here.
Flag 40 may be seen.
କଣ ହେଇଛି ଏଥିରେ ନୋଟିଂଟା IA 432, 431, 433 for condonation of delay, setting aside abatement, substitution, respondent number 13, IA for substitution for sole appellant. So sole appellant has died. Notice has been issued.
No, my lord. So far as the respondent one is concerned, I have received the miscase copy from her today.
Yes, sir.
So the first 431, this is for respondent number 1.
32, 31, 30, the respondent number for respondent number 13. And
One is the IA numbers.
charge.
No, that copy has not been.
611 by
Now he has filed one IA that is 611.
ଟିକେ ରୁହନ୍ତୁ ଆଗ ଏଇ ତିନିଟା ଏଇଟାକୁ ଆଗ ଦେଖିବା.
Next, I would have miscase through that is noting that.
ଟିକେ ଆପଣ ରହୁନାହାନ୍ତି ଏ ପ୍ରପୋଜ ଲିଗାଲ ଏରଙ୍କ ପାଖକୁ ନୋଟିସ ଯାଇନି ରେସ୍ପଣ୍ଡେଣ୍ଟ ନମ୍ବର 1 ର ଯାଇଛି
No, respondent number 1 is alive.
is alive. Sir, ki
Appellant died.
appellant sole
Sole appellant died.
and respondent
And
number
earlier, respondent number 13 died.
13 died.
That substitution petition is
Mr. Bhai, ଆପଣ ଟିକେ ବସିଲେ. There are 3 miscases 430, 431 and 432. It is in respect of which respondent?
Respondent 13.
Bas, ସେଥିରେ notice ଯାଇଛି. So notice has to go. ସେଥିରେ notice ଯିବ. Let us pass that order, then we will go to the other. All right. 430, 431, 432. ହେଲା. Issue notice to the proposed LRs as per the schedule to the petition by registered post, returnable within 4 weeks. Requisites be filed within 3 working days. List this matter like in the last lecture. Hello. What other miscase? Sole appellant kai?
611.
611. The sole appellant.
Hello.
So who are these? There is legal heirs. You are appearing.
The legal the wakalatnama has been filed.
Okay. So this has to be allowed. IA 611 of 2021. This is an application for substitution of the sole appellant who died on 21/8/2021. The present application has been filed in time. As such, the petitioners of this application being treated as respondent as appellant numbers 1A to 1
E.
E. No? E. No.
B, C, E, F, F.
F. E. F. Hello. 1E to 1F. Hello. Sri Devashish Tripathi has filed Wakalatnama on behalf of these
Legal heirs.
but these are appellants. These newly added. IA 474. Yes, you are saying something? No, 474. Now, what No.
474 for extension of interim order.
সেটা করিবে লাস্ট রে আর কোন আছে আর কি anybody else has expired so this substitution matter is taken. So what is 205 of 2015? Stay operation of the judgment. Already an order has been passed. Then 737.
Already order has been passed.
737 already order has been passed.
Flag B Raji, further order.
737 2007 stay order was passed. That is not continued.
And for continue of that stay order, I have filed an IA 474 of
2024, yes.
474 টা ফাইল করছেন the extension of the stay order.
Yes.
কিন্তু that order is not in force. My lord, can you give a glance to order?
I will pass that order or what? Stay the execution.
File kari for further.
কিছু না হিতরা আমি ফাইল করবে না the court does not have the power. What are you saying? Inherent power আছে কোন কোন the court which had passed an interim order cannot pass it again.
That order was passed. My lord, can you give a glance to order dated 2/8 as per
2/2018.
My lord.
Yes.
Whether that is order or not, I have not.
2/2018.
This case number.
Then, my lord, kindly give a glance to order dated 9/11/2017.
No. 2/2018 level দেখছি দে shall remain state till the next date.
Till the next.
Next date means next date of hearing of the miscase. That miscase has never been heard again. It is deemed to have continued.
Next.
তারপরে কোন substitution matter requisites file এই সব জিনিস আসছে
9/2017.
দেখো 17 বুক কাই পছু বুঝিবা আগে
No, sorry. 6/4/2018.
6/4/2018. হ্যাঁ
Appeal notice against response was.
সেটা notice matter রে গলা miscase has not been heard again.
Not extended.
কি miscase দরকার नहीं है till the next date মানে next date when the miscase is taken up for hearing.
That is not taken.
সেটা বিলকুল টেকন আপ হয়নি আজ টেকন আপ হচ্ছে আমি তাকে এক্সটেন্ড করে দেবো
So there is no necessary of filing of the 474.
ହେଲା ସେ ଫାଇଲ କରି ଦେଇଛି ତ କଣ ଫାଇଲ କରି ଦେଇଛି ତ କଣ
କିନ୍ତୁ ସେଟା continue.
IA 474 of 2024.
That is not continued.
ହେଲା by order dated ମୁଁ କ୍ଲାରିଫାଇ କରି ଦଉଛି ମୁଁ କ୍ଲାରିଫାଇ କରି ଦଉଛି by order dated 2/2018 this court as an interim measure granted directed that further proceedings in the execution case in question shall remain stay till the next date. In miscase number 737 of 2017, stop. Said miscase has not been taken up for hearing till date, which implies that the interim order is still in force. In such view of the matter, there is no necessity for filing another application for continuance of the interim order, which is therefore disposed of as infructuous. Hello. Tapre, how kono? Chetik to. So let's notice, list this matter on. Date karo. 4 weeks पे ही है ना तापर करो. Week commencing 4th November.
Consolidated cost title I will file.
Consolidated जोटा allow है ना. सही तरह से जो allow है ना. Consolidated cost title be filed within a week or within 2 weeks. Chala. Yes. Anything else, Mr. Bhai?
No.
Item number 9. May I plead the lordship, my lord. In this case, my lord, a memo has been given that the appellant number 1, namely Asa City has died, and the respondent number 1, namely Nomita Patna died. In this regard, appellant 1, already the legal rights of the
are already on record
in the court 2 and 3.
That's who?
Appellant 2 and 3 are the
appellant number 1, namely Asa Sethi, has died. Her legal heirs are already on record in the form of appellant numbers 2 and 3. Hence, no substitution is necessary.
Regarding
the name of the deceased appellant number 1 be deleted. Gola. Respondent number 1, namely Nomita Patnaik, has died.
In this regard, I will file the substitution petition within
the learned counsel for the appellant is directed to take steps for substitution within 2 weeks.
My lord, in this case, the respondent number 1 has died on 28/4/2021. My lord.
So he'll file petition for seeking condonation of delay.
lord.
Let him file.
The respondent number 2 has also died.
Respondent 2 has died.
2 also died. None of the respondent.
You are appearing for?
I am for both the respondents.
These respondents, you were appearing earlier. Will you appear for the proposed LR? So no, he has not filed any application, let him file, then we'll consider. All right. No, you calling again, is this matter what date could be? 4th November. What's
Short date.
sorted over?
Number 10.
2 weeks for a call. No, wait. 2 weeks for a date for a. 30th September. In the week commencing 30th September. Item 10.
At 10, there is a limitation of 37 days.
Notice has to go?
My lord.
2018.
Okay.
Or IA 1395 of 2024. Issue notice to the respondents by registered post, returnable within 4 weeks, requisites be filed within 3 working days. Is this matter on 4th November?
Item 11.
11, my lord, there is a but filed an IA for appointment of receiver, my lord.
Yes.
But matter can be disposed of on merits, my lord. Lordship may fix the matter for final hearing.
Who's appearing? You are appearing.
Your Lordship, I'm learned senior is supposed to argue.
Dispute between the children of first wife and second wife.
I'm on behalf of the principal respondent.
So you are appearing, you are already there on record. What do you say when he says that the matter can be disposed of finally at this
Your
stage?
Lordship, I request for a passover for the date.
No, I'm not taking up today. I'll fix a date for hearing.
Your Lordship, that's what I'm saying. Can it be a passover for the day my senior is supposed to?
No, it's for final hearing. That is what he's saying. Otherwise, he'll press his application for receiver. Why should we consider that application if the matter itself can be disposed of?
Your Lordship.
It is stated at the bar that the matter can be finally disposed of. LCR ଅଛି ଦେଖିଲ? ଆଜି ତ LCR ଆସିନଥିବ କେମିତି ହବ? ଆସିନି? ଏ କେବେଠୁ ହେଲାଣି? Admit କେବେ ହେଲା?
During COVID time, it was admitted.
COVID time admit ମାନେ ତା date ତ ଥିବ? Admit ହେଇଛି 13/2/2020. LCR କେମିତି ଆସିନି ପର୍ଯ୍ୟନ୍ତ? LCR ମଗାଇନି?
13th February 2020.
Yes?
13th February 2020.
No, why was the LCR probably was not called for? No, ଡାକିଦବା LCR ମାଗି ଅଛି ନା LCR ମାଗିଦବା ହେଲା so it can be finally disposed of at this stage. However, it is seen that the LCR has not been called for. Stop. Call for the LCR with instructions to the court below to transmit the same as early as possible. To transmit the same to this court. To transmit the same so as to reach this court by what date करते हैं 10 दिन पूरी डेट करते हैं by before 30th September. Place this matter in the week commencing 30th September under the heading hearing.
Interim order to collect.
ତାପର week ଟା କେତେ ହଉଛି? We'll take it up on 21st October. ତା ପୂର୍ବରୁ ହେଇପାରିବ. This matter under the heading hearing in the week commencing 20th October. Yes.
Interim order to continue.
Interim order to continue.
I don't know 12.
Limitation notice on respondent 3-1 delivered to the
take fresh step Miller on
fresh notice be issued on respondent number 3(1) I by registered post fixing a short returnable date because it's be filed within 3 working days. Place this matter in the week commencing 11th November. ଆଉ କିଛି କରିହବନି।
Note 13.
5 and 6 returned undelivered with postal report not claimed. Not claimed মানে কো? Yes.
Not claimed.
What is the meaning of not claimed? You take fresh notice. Take fresh notice.
Not claimed is.
Not claimed মানে sufficient.
Sufficient.
No, we do not know. He could have written refused. He has not written refused. In a negative manner, he says that not claimed. I will not accept it. He could have, what stopped him from writing refused? That I would have immediately said that it is sufficient. ये postal authorities को भी विश्वास नहीं, ये कौन कारवार कर दी थी किसी ने? Issue fresh notice on respondent number 1, 5 and 6.
1, 5 and 6.
With by registered post, returnable within 4 weeks. Requisites be filed within 3 working days. Less this matter in the week commencing 18th November. Yes. Item
number 14.
14. Yes. For a further order.
Number 14, my lord. Appearing for the respondent number 1, lordship.
Yes.
Pray for an adjournment to file an objection to the IA, my lords.
The status quo was granted.
Granted. Interim status quo was granted. Today is just for hearing on the side of for the IA.
IA 8 of 2024 elekhontu. Your good name?
Nityabrata Behuria, N Behuria.
You are appearing.
Yes.
Sri Nityabrata Behuria has entered appearance for the all the respondents.
No, respondent 1, lordship.
For respondent number 1 and submits that he would file an objection to the IA. Let such objection be. What about the other respondents? Notice has been issued. Notice जाइए तो? Whether notice has been served or not, जना पुरने?
Requisites were filed on 5, 9.
Yes, yes.
And every filed.
अच्छा हो. Let's this matter. Kebere.
28th October.
May I pray for 21st October week commencing?
In the week commencing 21st October, objection if any be filed in the meantime, office to indicate the status of notice as regards the other respondents.
Much obliged.
Item
15. 10th November को appeal टा fix है.
Yeah, I mean, I item to order कुछ.
Much obliged.
Item 15.
15 minor, there are 3 IAs.
There are 2 IAs on my board, 782 and 784. 783 टा करोड़ रही तो इसे scan करना थी. All 3 are there. Yes. Substitution.
No, madam.
Now.
It has come for limitation, exemption of court fee and stay of execution.
What about exemption of court fee? Let us first take it up.
Then my lord, my income is less than 1 lakh. For that I have filed the IA, my lord. That is-
Income is, where's the income certificate and were you exempted in the court below?
My lord.
Where's the decree?
Page 41 of my opinion.
ये देखिए आगे इधर अच्छी ना है तो देखिए ये कौन सी डिक्रीट है
That again, तौल कोर्ट रे appellate court. Previous page.
आइए 784 of 2024 है तो ना 782 of 2024 this is an application for exemption of this is an application for exemption of for filing court fees on the ground that the appellant having annual income less than rupees 1 lakh was exempted by the courts below. In this regard, learned counsel for the appellant files certified copy of order dated 22/4/2024 passed by the first appellate court, wherein taking note of the annual income of the taking note of his annual income, comma, he was exempted from filing court fees. Stop. In such view of the matter, the petition is allowed. The appellant is exempted from filing the court fees. Then you have limitation notice
Sir,
कर
execution
कौन करे नो delay no है लेकिन कौन करे notices को मुझे अन्य you are from a very good civil chamber, you educate me.
That since the executing court is deputing a police force for delivery of possession.
Delivery position. All right.
Urgent.
IA 784 of 2024. There is only 7 to the respondents by speed post, fixing a short returnable date. The requisites be filed by tomorrow. List this matter on.
Commencing 18th November.
এটা কাইন্ডলি করছি পাই হ্যাঁ একদম পাখের করে পুরো ফটো বিচ ছাড়ি করো in the week commencing 7th October. No. IA 783 of 2024, notice as above. It is directed that the executing court shall not finalize the execution proceeding in EP number 2 of 2022 till the next date. Yes. Sir,
Item number 16.
No, urgent certificate.
urgent copy.
Well, that's item
You are
number.
relying upon a judgment?
Bombay High Court.
ହଁ ଆମ ହାଇକୋର୍ଟରେ ବି ଅଛି ଆମ ହାଇକୋର୍ଟରେ ଅଛି କୋଉଟା that it will otherwise it will become infructuous.
Limitation ହେଇଥିଲେ ମଧ୍ୟ limitation notice ସାଙ୍ଗରେ stay
There is also a provision
41
order 41
3A clause of
ହଁ ଗୋଟେ sub clause ବି ଅଛି but that is under I think the circumstances are different. Let me see.
lordship has the inherent power under 151.
Yes, that was. When there is a provision, maybe. Yes, find out that provision. Find out. Error of the rule 3, error of time. Yes, what is this matter?
It's item number 16, Mr. Sibashish Mishra is engaged by the clients, Millets.
Yes.
He's on his way, Millets. He'll be.
What has this, why has this matter been listed? For dispensing with filing of certified copy?
Yes, Millets.
It has not been admitted.
No, Millets, this is a fresh.
So I'll grant you 2 weeks time to file the certified copy.
Millets, I'll file it.
All right, let them, we can take up the matter for admission also.
Millets, the execution, there is an execution petition.
All right, let him come. We'll take it up tomorrow.
Millets, that.
All right. Tomorrow admission matters. Pass out the kitchen. We'll take it up tomorrow. All admission matters. Tomorrow there is a part third matter I'll take up first. Where Mr. Khuntia was arguing. Thereafter I'll begin from admission matters. Aji ଆଉ କର No, ଆଜି ଆଉ କିଛି ନାହିଁ କାଲି କର
17 में मुझे नेक्स्ट वीक आसो